The Appellate Division, First Department, is now in session. Good afternoon and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Acosta.
Good afternoon, Your Honor. Jan Hoth for Appellant Jose Acosta.
You have 4 and 1.
Thank you.
Good afternoon, Andrew Seawald for the respondent.
You have 4 minutes. Creo versus Finn.
Good afternoon, Your Honor. Appellant.
You have 5 minutes.
Thank you, Your Honor.
No respondent, right?
That's correct, Your Honor.
Matter of Kezia R. Submitted. Raji versus SG Americas. Submitted. Skyling Travel versus Jane Holdings. Submitted. People versus Homes. Submitted. Perez versus Masonry Services.
Good afternoon, Your Honor. Martin Gold for Appellant Latier Control.
You have 6 and 2.
Thank you.
Respondent Perez, is that the first respondent up?
Yeah, Jack Newhouse for plaintiffs respondents.
You have 5 minutes.
Thank you, Your Honor.
Defendant and cross appellant Masonry Services, Inc., and James S. Herrera, Jonathan Greenbaum.
And Judge, good afternoon. Scott Richmond for Manuel J. Herrera, cross appellant and respondent.
Okay. So, Mr. Richmond, you have 3 minutes, and counsel for Perez and Masonry, counsel for Masonry Services has 5 minutes.
Thank you.
So it's 5, 5, and 3. People versus Matthews.
Good afternoon, Your Honor. Jose David Rodriguez Gonzalez for appellant Mr. Matthews.
5 minutes.
ADA Emily Aldridge for the people.
4 minutes.
Thank you.
Luck versus O'Neill.
Good afternoon, Zach Shapiro for appellants.
You have 2 minutes.
Thank you.
Respondent. Right, is the respondent present yet? If the respondent arrives, the respondent has 2 minutes. Total Asset versus Metlife, Inc.
James Ferraro for appellant. Could we reserve 3 minutes for rebuttal, Your Honor?
Okay, so you have 9 and 3 then.
Thank you, Your Honor.
Okay.
Mabel
There are 3 respondents who are arguing on this, who are splitting 12 minutes, but now answer the calendar, please.
Maeve O'Connor of Debevoise and Plimpton on behalf of the AXA, Guardian, Hancock, Mass Mutual, Prudential, and TIAA appellees.
Stephen Dellafera of Denton's. Stephen Dellafera of Denton's US LLP on behalf of the Genworth respondents.
Good afternoon, Your Honor. Ellen Dunn of Sugi Austin LLP on behalf of defendant respondents MetLife Inc., Metropolitan Life Insurance Company, New York Life Insurance Company, and New York Life Insurance and Annuity Corporation. My partner, Carolyn Thompson, has been admitted pro hac vice for purposes of this argument by this court's letter dated August 22nd, 2019. I request that she be permitted to participate in the appeal today.
Okay, that request is granted. And as I've indicated, the 3 respondents have a total of 12 minutes to split among themselves. This case is going to be argued last because Justice Kern has recused herself. In the event that there's a tie vote, a 5th judge will be vouched in, but we'll hear it last. Robinson versus Lohman, submitted. People versus Perez, submitted. Blue Water Realty versus Salone Management.
Good afternoon, Your Honor. Stephen Uden for appellant.
Good afternoon, Your Honor. Jack Lasser for the respondent.
Okay, you each have 2 minutes. Turner Construction versus Nastasi Associates.
Good afternoon, Your Honor. Meredith Shiroki-Paley from Spiro Harrison for Appellant Nastasi and Associates.
5 minutes.
May I please reserve one of those minutes for rebuttal?
Yes.
Thank you.
And Alexander Saunders, the law firm of Bakar and Abramson for Plaintiff Respondent Turner Construction Company.
5 minutes.
Thank you, Your Honor.
Commissioner of DSS versus New York Presbyterian.
Good afternoon, Your Honor. Stuart Perry for Appellant New York Presbyterian Hospital. I respectfully request that Mr. Franklin Solomon, who has been granted pro hoc vici permission by this court's letter of November 4th, please be allowed to argue the appeal.
Yes. So you have 4 minutes. Respondent?
Jesse Townsend for the respondent.
4 minutes.
Thank you.
People versus Rodriguez.
Good afternoon, Your Honor. Taylor Poor with the Office of the Appellate Defender for Mr. Rodriguez.
You have 5 and 1.
Thank you.
Felicia Yancey for the people, Your Honor.
5 minutes. Tsumpus 1105 versus 1109 Lexington.
Mikhail Schenker of Klein Slovic for Respondent, Tsumpus 1105, Equities LLC.
You have 5 minutes.
Thank you.
I know the other attorney was having problems. He or she has 5 minutes too. Ditech Financial versus Rectus 7-0.
Good afternoon, Your Honor. Adam Swanson for the appellant, Ditech Financial, and I'd request to reserve 1 minute for rebuttal, please.
5 and 1.
Good afternoon, Paula Miller for the respondent.
5 minutes. Khalil versus City of New York is submitted. McCullough versus 1 Bryant Park.
Good afternoon, Your Honor. Anthony DiStefano for the appellants 1 Bryant and Tishman.
You have 5 and 1.
Good afternoon, Your Honor. Respondent, component, Darrell, John, Conway, Farrell, Curtin, and Kelly.
You have 5 minutes.
Scott Singer for the plaintiff respondent.
And you have 5 minutes. I remind the attorneys to please keep your microphones muted while until it's your turn to argue. And I also ask you not to speak over the judges when the judges are speaking. That's our usual rule, and it's especially important when we're doing the argument virtually. First case for argument, People versus Acosta.
Good afternoon, Your Honors. Jan Hoth for appellant Jose Acosta. The purported appeal waiver in this case is invalid. Mr. Acosta pleaded guilty over 1 year before the legislature mandated the appeal of all statutory speedy trial claims notwithstanding a plea of guilty. By a matter of common sense, a defendant cannot waive the right to appeal a claim he has at that time no reason to believe would be appealable. Also, the record here is absolutely devoid of any evidence that Mr. Acosta's appeal was entered into knowingly and voluntarily. Rather than ensure that Mr. Acosta understood that the waiver of the right to appeal is separate and apart from those rights automatically waived by a guilty plea, the court conflated the two concepts.
Counsel?
Yes.
In this case, didn't defendant also sign a written waiver, and didn't he discuss that waiver with his counsel?
Your Honor, the written waiver here yes, he did sign a written waiver.
And did he discuss it with counsel?
He was asked if he discussed it with counsel, and he answered yes. The problem, however, is when you look at the oral waiver. The oral waiver in this case was so bad that if it's upheld merely because of a written waiver, this court would in effect be enacting a rule that we don't care what the courts do anymore, as long as there's a signed written waiver and the defendant says he spoke with his attorney about it. But even if this court was willing to go out on that particular limb, and I don't think they are, the point here, even the written waiver isn't sufficient to waive the statutory speedy trial claim.
How do you deal with didn't we rule on this issue on People versus Pearson already?
In People v. Pearson, the court decided that the statutory speedy trial claim could be waived. My argument in that case was that it could not be waived at all, that there shall be reviewable mandated review, and the court disagreed and said that it could be waived. My argument here is that it was not waived.
So counsel, I'm sorry, how is the oral waiver defective? The court specifically stated to the defendant in terms of his right to appeal that he was giving up his right to appeal as well as giving up the right to have appeal any rulings made in the case.
Your Honor, if you look at the court's colloquy, the court explained to Mr. Acosta the rights that he would be giving up by pleading guilty. Its next sentence was, in addition, had you gone to trial and been convicted, you would have had the right to appeal. That not only does not explain to Mr. Acosta that the court is about to explain a completely separate and distinct concept, but it's an incorrect statement. By saying that had you gone to trial and been convicted, you could have appealed, the court was pretty much saying, well, you pled guilty, so you have no right to appeal. In addition, if you look at the court statement, it specifically said that he would retain the right to challenge a constitutional speedy trial claim, but it never explained that there was a difference between a constitutional speedy trial claim and a statutory one, and that's the same defect in the written waiver. If you're not going to explain to the defendant there's two different concepts, saying one can be appealable and not mentioning the other can hardly be a knowing and voluntarily waiver. Mr. Acosta wouldn't have understood what was happening.
But the bottom line was the court informed Mr. Acosta that he was waiving that right, regardless of whether it was statutory or constitutional. He said, you're waiving your right, you're waiving any speedy trial issue.
But he's not waiving any speedy trial issue. The court specifically said he retained the right to appeal a constitutional speedy trial claim. That was the law.
Any other questions for counsel? Thank you.
May I proceed?
Yes.
Good afternoon, Andrew Seawald for the people. First, I would just say that the court's denial of the speedy trial motion itself was correct, as I have laid out in my brief. If anything, the court overstated how many days were chargeable to the people. And so in any event, regardless of the validity of the waiver.
You're referring to the period of August 29th to September 15th.
Right.
That was charged at 35 days.
That's right. So I think there was a tabulation error, and then there was also an error where the court included a period where the transcript actually supported the.
Why don't you address the issue raised by defense counsel of the seeming failure in the oral waiver to indicate that this is a separate right?
Well, the court laid out that it was separate, and I think one of the arguments that the defense raised in its brief was that the court addressed the two different types of rights, the rights that are ordinarily waived and the right to appeal, too close together during the colloquy. But the fact that the court addressed them one right after the other helped actually make clear to the defendant that these were two different sets of rights. And the court's language, the specific language, we can really try to pick it apart for the exact phrasing, whether the phrasing was ideal or not, but that's where the written waiver comes in. And the written waiver is an important supplement to the oral waiver. The court made sure that.
Did the court in fact conflate constitutional speedy trial as opposed to statutory speedy trial?
No, I think quite the opposite. If the court said that the defendant would retain the right to make a constitutional speedy trial argument, then the clear implication is that the the defendant is waiving a statutory the right to appeal a statutory speedy trial claim. And so, no, the court did not conflate them. The court didn't explicitly discuss the statutory speedy trial claim, but there are lots of claims, potential claims, that a court doesn't explicitly discuss when going through a waiver of appeal. There's no way that a court could possibly discuss every potential claim that someone could raise in an appeal. And as was pointed out, the court said that the defendant was waiving any ruling, his right to appeal from any ruling, with the exceptions of those specifically mentioned. And
any other questions for counsel? Thank you.
Thank you.
Your Honors, a defendant cannot knowing and voluntarily waive a right by implication. My adversary just conceded that the court did not explain to Mr. Acosta that the waiver of the right to appeal is separate and distinct from those rights automatically waived. What the court said was, in addition, if you had taken this case to trial and been convicted, you could have appealed any order, but by pleading guilty, you waive that right.
Assuming the waiver was in fact invalid, how do you respond to the speedy trial ruling?
Your Honor, I think that it's very well laid out in my brief, but very briefly, if you look at the Court of Appeals case in People v. Wells, the Court of Appeals there decided that the people erred and were charged with time when they did not advance a case after the defendant had won the reversal of his conviction and leave had been denied. The Court of Appeals made clear in that ruling that an appeal ends when the appeal is concluded. Therefore, any time that is excludable as a result of motion practice ends when the motion is decided.
What about People v. Mercedes, which was decided after Wells?
I'm sorry, I don't understand what.
Since Wells, this court has allowed a reasonable period of time to prepare for a trial after an unsuccessful plea. I believe, if I'm not mistaken, that was People v. Mercedes. So yes. Why then would that time not be excludable as a reasonable time to prepare after the unsuccessful plea? The unsuccessful plea.
Because the statute makes no allowance for that. The statute says you exclude time during the pendency of a motion. It doesn't say during pendency of a motion and a reasonable time after decision. People v. Wells made it clear that the Court of Appeals agreed that time spent during the pendency of a motion ends when the motion is decided. The reasonable period of time that the people get to prepare after that should be chargeable to them. That's what speedy trial is all about. How much time do they need to be ready? In this case, even the court agreed it was giving them an unreasonable amount of time. So even if the court is going to adhere to its ruling that they get a reasonable amount of time, they got more than a reasonable amount of time. They never announced ready, off calendar or not. They never advanced the case. They took an amount of time that even the court agreed was unreasonable. And
so by your count, how many days does that add?
Well, based on my count, if you look at the entire period.
For this issue that you brought up about the time after the motion was denied.
That was, I believe, either 53 or 63 days.
You say that when he had 53 to 63 days.
It was a 53-day period, 63 days from that, but then the same analysis applies to the period following the plea negotiations. Again, there's nothing in the statute that gives the people a reasonable time following their efforts to work out a deal. The pendency of those negotiations are excludable. But as my position, People v. Wells makes clear, it ends when the negotiations end. And that was another 53-day period. So over 100 days were excluded for the people to get ready. But that's what speedy trial is all about. The people are supposed to be getting ready.
Any other questions for counsel? Thank you. Thank you both.
Thank you.
Keogh versus Finn.
Good afternoon, Your Honors. This is Dan Ratner from Heidel, Petone, Murphy, and Bach. I represent Lifetime Fitness and Christopher Finn, the appellants on the appeal. The issue is whether a clear and unambiguous release that the plaintiff signed at the time that he signed up for the gym, a separate release, a fitness program agreement under which he paid an additional fee of $131 per session on top of the $200 per month monthly fee he was paying, it released any claim.
This is Judge Kern. How have you met your burden on this particular motion of showing that the gym is not a recreational facility? It's one that provides instruction.
Well, what we showed was that the plaintiff signed a separate agreement, which was clearly instructional in nature. That's what we showed. We showed that he was paying a separate.
The cases, the addresses of which there are a number, don't they all speak in terms of the facility itself rather than the specific activity that's being challenged?
Well, it's interesting, Judge. In the DeBell case, this court cited the Lemoyne case, a third department case, in which the third department specifically said that a case involving a mixed-use facility presents different kinds of issues. And you have to look, yes, included in that is what the gym was set up for, if it had a recreational purpose, but also you have to look at whether or not there was an instructional purpose. And here what you had, unlike in the DeBell case, is a situation in which the plaintiff specifically testified in his deposition that the reason he signed up for these personal training sessions was because he wanted to learn new things. He had been working out for many years, and he hadn't had a trainer in many years. He wanted to learn new things. That's a 253 of the record. So that's, I think, how we met our burden. In addition,
but counsel, this is Justice Catholic. In a more recent case in the first department, which is we often look at from 2016, HSU versus Krav Maga, which I believe Judge Kern might have written this opinion in Supreme Court, didn't we say that even if that's true, we have to look at the facility as a whole, what they offer. Even if he went to learn new things and he was working with an instructor and signed a special agreement, don't we have to at least look at what the facility as a whole does? And they talk about the spa and all the equipment and all of the recreational facilities they have, and we don't really have enough. So doesn't that at least raise an issue of fact at this point in the case?
Well, maybe it would in a different kind of case. I don't know, Your Honor, but in this case, you have a situation in which you have a plaintiff who had been working out for years. He was a highly competitive individual. He wanted to learn how to do more than 120 push-ups in 2 minutes. He was clearly trying to get better well beyond the typical gym goer who goes and works out on his own. And I think you cannot look simply.
Let me turn your attention, because your time is running out. What about the fact that the trainer pushes him to go forward even though he's complaining about pain?
Well, I'm sorry. He complained about pain, and then he also admitted that he could stop at any time. And in fact, he continued on with that workout beyond simply doing uneven push-ups. He did 2 other highly difficult exercises. He could have stopped at any time, and he admitted that. And so, the plaintiff waived any claim of negligence. He released it. So even if my client...
I wasn't talking about his release. I'm talking about the assumption of risk. I mean, the trainer tells him to push forward even though he has pain. Does that create an issue of fact?
Well, if he's released the claim, assumption of the risk doesn't really matter. But in any event, he testified that he was well aware He knew, for one thing, he knew he'd had a prior injury, and yet he kept going. He signed up for this stuff. I mean, it's almost inherent in personal training, I have to say, when you have a gentleman who had a prior history of shoulder and elbow problems, and he said, well, let's do uneven push-ups anyway. And then he kept going. It was at the beginning where he complained of pain, and instead of stopping, he just kept going. And I think he assumed the risk that he can injure himself, frankly.
Any other questions? Thank you, Counselor.
Thank you.
Perez versus Masonry Services.
Good afternoon, Your Honors. May it please the court. My name is Martin Gold, the attorney for defendant appellant Latier Construction Corp. The trial court below erroneously denied relief to Latier for an apportionment of liability on its cross claims for fraud, contribution, and indemnification as between the co-defendants, which, if granted, would not have affected the plaintiff's ability to collect on the joint and several judgment of liability against the defendants that were found liable in the case.
Well, this is Judge Kern. I mean, this occurred after a multi-day trial. Why wasn't that a factual issue which the judge was entitled to evaluate based on the evidence that there was in fact involvement by a client in the underpayment of prevailing wages, and therefore your client had responsibility?
Your Honor, we don't deny the responsibility to the plaintiffs under the breach of contract case, but there was no contract between Latier and MSI and the individual co-defendants. And it was only after the trial that the court, there was another motion.
Counselor, this is Judge Singh. Are you arguing that your client doesn't have any kind of responsibility to ensure there's compliance with the prevailing wage requirements? Can you just do it? Can you turn a blind eye and not worry about it, even though factually you see a lot of employees there, their payroll records, the payroll records comport with the amount of employees, et cetera, et cetera? Aren't those all issues of fact that the trial court resolved against your client?
Your Honor, they did vis-a-vis the plaintiffs, but not vis-a-vis the co-defendants. And so there's cross claims that sound in tort where an apportionment of liability can be made between the co-defendants for their relative degree of culpability on the fraud. Now, it was the co-defendants.
But counsel,
yes.
Didn't Judge Angoran find, after hearing all the testimony, that Latieri and Valley Stream and the individuals all were working in concert? So they couldn't really make a determination about that, but they all were acting in concert. Isn't that what he found after hearing all the testimony from all the witnesses?
Yeah, that's what the decision below said, that they acted in concert, but there's really no evidence of that because it's Latier, it was the co-defendants that submitted fraudulent payroll records that the plaintiffs don't even show up on. Nobody knew that these plaintiffs were even working on the job site because they don't appear anywhere. So the fact that Nick Latier walked around the site on a few days when he was going to a meeting doesn't impute knowledge to him that the co-defendants were committing fraud by submitting fraudulent records.
Chancellor, I'm sorry, this is Judge Kern. I have a separate question which goes to your motion, your CPLR 3025 motion to amend the pleadings. I'm trying to figure out how the individual defendants were still in the case for you to make that motion, or how you brought them back into the case when you brought the claims against them to pierce the corporate veil. I mean, because the case had already been discontinued against them at that point. So how were they viable parties before the court against whom a motion could be made at that point?
Well, that's a good question, Your Honor, but they had been represented for 6 years all along. So then you're sitting in court and you're having a trial, and now all the fraud comes out, and the court pierced the corporate veil as a result of the.
But you didn't deal with the point that Judge Kern started with. They're let out of the case, and I know there is intimations of impropriety in their having been let out of the case, that there's some collusion with the plaintiff, but they're let out of the case at the beginning of the trial. Isn't that so?
Your Honor, the plaintiff.
But it's a yes or no question.
by the plaintiff, Your Honor, but there was still cross claims against the corporate co-defendants. And then during the course of the trial,
were there cross claims against the individual defendants? I know the individual defendants were originally named in the case, but now you get to trial and they're let out. I mean, presumably they're let out. They could have walked away from this, couldn't they have?
Right, but they sat through the trial and were represented by counsel throughout the trial, and it was only during the trial.
But because they were called as witnesses besides, were they not?
Yes, they were, Your Honor.
Okay, so again, they're let out at the beginning of the case. And you want them back in. How do you get them back in? There's an oral motion, right? At the close of the evidence, there's an oral motion made pursuant to CPLR 3025, right?
Right.
What's the pathway to bring them back so that now suddenly they become subject to being personally liable, having been let out of the case?
Well, because they sat through the trial, their attorney was there, and the evidence at trial it showed that they pierced the corporate veil, and we were allowed to amend to include cross claims now against them.
How did you have jurisdiction over them, though? That's, I guess, what I'm wondering. How was there, once they were discontinued from the case and they were no longer parties, what was the basis to assert jurisdiction over them at that point, since they were no longer parties, unless you used some procedural mechanism to bring them back into the case?
Well, I don't know that there was a written discontinuance of the case against them. The plaintiff discontinued.
Well,
we still had, I'm sorry.
Were they still in on cross claims?
The corporations were still in on cross claims.
There were no cross claims against them personally.
That's correct, Your Honor.
And when you say they were sitting, this is Justice Weber, when you say they were sitting there as witnesses. They were not sitting there as as parties to the lawsuit. Is that correct?
I don't think that's correct.
So they were sitting there for other than just being witnesses?
They were there throughout the entire trial.
But as witnesses, not as parties to the litigation.
Well, I don't know. I don't think that question's been answered.
You mean had they not sat there, they wouldn't be subject to this?
Well, I don't know. Their attorney wasn't there just while they were on the stand. Their attorney took part in every phase of the trial.
In terms of what? Examining witnesses as well, making arguments?
Yes.
Did he do it representing them, or was he representing the corporations that they were part of?
Well, as far as Manuel Herrera goes, I think Mr.
Were those attorneys there for them in their personal capacity, or were those attorneys there because they were representing corporations of which these people, these individuals, have now had the corporate veil pierced?
Both. They represented the individuals and the corporations.
But the attorneys were there because they were representing the corporations. So you have time in response. So let's hear from a first respondent.
Is it plaintiff's respondents? Jack Newhouse. Good afternoon, Your Honors. Since you have noticed that Latier in their reply brief they don't really address the damages that plaintiffs are seeking. They do address it briefly in their initial brief, and it wasn't really addressed during this current oral argument so far. So plaintiffs will rest on their brief unless Your Honors have any questions. I'd be happy to answer.
You let the individuals out at the beginning of the case?
Yes, Your Honor.
Thank you. I guess that brings us to, is it Perez, Respondent Perez?
Oh, that was
no, I'm sorry. I mean Respondent Masonry Services. Is that who's next? If I'm wrong, whoever is next, go ahead.
Mr. Newhouse, while we're waiting, did you execute a formal stip of discontinuance with respect to the defendants, or was it just oral?
I think it was just oral. I don't know. We didn't sign a stipulation of discontinuance.
On the record.
Correct.
Was it on the record?
I believe it. I thought it was. I'd have to check back the record now to see, but yes, we all thought it might have been off the record, and then Judge Engeron put it on the record afterwards.
Okay, thank you.
Okay. Is the either of the respondents present?
Yes, Judge. Scott Richmond for Manuel J. Herrera. Good afternoon.
Go ahead.
Okay. As far as the argument regarding acting in concert, I think that the judge made that decision pretty clear. For Letier to try to push off any liability, specifically by apportionment onto Manuel J. Herrera, would be inappropriate under the circumstances. Letier had an active presence on the job site. They received a notice of underpayment from the Department of Labor, knowing, so they should have known at that point that the individuals on the job site were not being paid the appropriate prevailing wages. And also the payrolls weren't certified. Letier proffers the theory that you can certify the payrolls with anything but a certification or other collateral documents or additional documents to it, but that's not the case. Otherwise, judges, I'm going to rely on my papers. Thank you.
Your Honor, Jonathan Greenbaum for.
But just a moment, Mr. Richmond.
Yes, Judge.
So do you have anything to say about the personal liability that's been imposed? That's been imposed upon the two individual defendants?
As far as my client, Manuel J. Herrera, Judge, I don't think that the corporate veil of Valley Stream should have been pierced under the circumstances. I made my argument, my papers on that. There's no evidence adduced at trial that Manuel J. Herrera failed to adhere to the corporate form of Valley Stream. There's no evidence regarding inadequate capitalization or any evidence whatsoever in the record regarding how much money was in any of the bank accounts. There was no evidence.
Mr. Richmond,
Yes, Judge.
wasn't there actually a question as to whether or not Valley Stream really existed as a corporation? They had absolutely no records relating to this project. Wasn't that part of the problem that Judge Engoron considered during the trial and that was asked about by the witnesses?
Yes, Judge. Sorry, Judge. That was an argument that did come up. However, it was my client testified that Valley Stream maintained its own bank accounts, office, staff, and its own insurance policies.
How did you have no
Valley Stream was actually, sorry?
How did you have no records? I mean, your story was kind of far-fetched.
Judge, that's the story that my client gave. It may be far-fetched to some, but that's the story that was given.
Counselor, did Valley Stream file false payroll records? And if it did, could the tort be could the individual principal be found responsible for that tort?
Well, there was a finding that my client had committed fraud under the circumstances, Judge, but no, I can't speak to that specifically, Judge.
Okay.
Your Honor, Jonathan Greenbaum for Masonry Services, Inc. and James S. Herrera. My microphone was muted for some reason. With respect to the 3025 issue, James S. Herrera did not sit through the entire trial. He was called as a witness for MSI, not in an individual capacity. Judge Engoron did dismiss counts 2 through 6 on the record. I think I cited that in the record site in my brief. As to Your Honor's question that was with respect to Manuel J. Herrera, there's no evidence in the record that James S. Herrera committed any tort or had anything to do with this job. James S. Herrera is a principal of Masonry Services, Inc., not Valley Stream Construction. It's stipulated by the parties prior to trial that Masonry Services, Inc. had no contract with Letier for this job. The employees on the job were Valley Stream employees. With respect to the issue of fraud, Judge Engoron equivocally and clearly found there was no fraud. Why? Because Letier participated and acted in concert with Valley Stream to deprive the plaintiffs of a prevailing wage, pursuant to their own contract with the owner of the project, as well as its own contract with Valley Stream. The elements of that are: 1, the payrolls at issue were not even certified. If you look at the payroll records, which are in the record, we've cited to them, they have none of the required certifications. This is a Davis-Bacon Act job because there was federal funds received. There's supposed to be 3 certifications made on the payrolls under 29 CFR 5.5. None of those certifications were made. In fact, Latier, which is part of the record, admits that it didn't know who from Valley Stream certified the payrolls. Why? Because no one did. And that's unrebutted testimony. 2, Latier had an active presence on the job. That's a main element of Judge Angorum's decision, and the evidence supports that. Latier had 2 individuals there full-time whenever work was being done on the job. One was an individual named Billy Mulligan, who was not even disclosed during discovery to any of the other parties.
Counsel, this is Judge Singh. Was Latier served with a notice of underpayment in this case?
Yes, they were. So Latier was served with a notice of underpayment. That's one of the other issues regarding, I believe, one of the first payrolls on the job. It's an exhibit that's in the record, and they're CC'd in there as the general contractor. So in addition to their active presence on the job, they were on notice that there were underpayments, i.e. employees who were not on the payrolls. Latier was served with that notice. In fact, Latier produced that notice during discovery. So it's not even an issue. And it clearly shows employees who are not on the payrolls. At that point, which is the first week of the job, Latier's on notice that there's an issue here. Just as importantly is Latier's own contract with Valley Stream does not comply with the Davis-Bacon Act. The Davis-Bacon Act clearly, and this is in the owner-Latier contract, sets forth what Latier is supposed to do as a prime contractor. They're supposed to have a compliant Davis-Bacon subcontract. They didn't do that. If you look at the prevailing wage clause in the Latier Valley Stream contract, all it says is this is a prevailing wage job. Submit your payrolls when you submit your periodic requisitions. That right in and of itself doesn't comply with Davis-Bacon. In Davis-Bacon, the payrolls are supposed to be submitted weekly. Latier has an affirmative duty to ensure compliance. They did not do that. They admitted to not doing that by their own contract with Valley Stream. It's not periodic submission of certified payrolls. It's weekly certified payrolls. And the reason for that is so the GC, general contractor, can uncover these improprieties with respect to the certified payrolls.
Counsel, any other questions for counsel? Thank you.
Thank you, Your Honor.
Yes, briefly in rebuttal, if I may, regarding the Davis-Bacon Act, the plaintiff waived all their federal statutory claims in this case when they allegedly let the individual defendants out of the case. This case wasn't prosecuted under the Davis-Bacon Act, and those provisions in the contract run between the contractor and the government, not the plaintiffs. I would also say
Counsel?
Yes.
Counsel, I'm sorry. I just want to go back to the issue of letting the defendants out, the individual defendants.
Yeah.
Was this done on the record? How did it occur, and what was your position? Did you object? Did you take a position? What did you do at that time?
Your Honor, truthfully, I did not try the case, and I can't answer that question. We objected to it because Latier was being set up.
Hold on. At the time, I assume that whatever occurred happened on the record, correct?
No.
And at that time, was there an objection to the individual defendants being discontinued?
As Mr. Newhouse said, he thought it was off the record.
Well, no. It was off the record, but then the court presumably made a statement on the record. Was there an objection at that point?
Your Honor, honestly, I can't say yes or no. I can't answer your question, and I don't want to mislead the court. But I will say that in terms of the 3025 issue, once it was established at the trial that the individual defendants were involved in the fraud, and we conformed the pleadings to amended the pleadings to conform to the evidence, the court can view those cross claims for fraud, contribution, indemnification as ones that maybe should be characterized as a third party claim for indemnification or contribution, and rather,
against parties who have been let out of the case. against parties who have been let out of the case?
If the court would overlook the form of the pleading and call those cross claims third-party claims, then yes, they would be brought back in 2 minutes after they were allegedly let out as third-party defendants.
But it wasn't 2 minutes later. They were let out at the beginning of the case.
Oh, they were there the whole time. And then
any other questions for counsel?
Can I make one comment on the damages, Your Honor, if I may?
Go ahead.
That we, our brief addresses the damages, and the only thing that the court below relied on was the 10-year-old memories of all the plaintiffs that had the same perfect memory as to the days and dates and hours they worked, which do not.
But actually, what else could the court have relied upon, because there were no records?
Exactly, Your Honor. There were records. There were the photographs that showed the progress of the work, and there were the payment requests that showed.
But those aren't the records of the payments for these individual plaintiffs.
Those are the payments made under the contract according to the progress of the work, which contradict what the plaintiffs said they were doing when they said they were doing it. Because if 90% of the work was done by December and they're saying they're doing that work in May, those records, nobody said those records were phony. And those records, the court just disregarded them. So they said that the payroll records, the weekly payroll records, are too perfect because they're all the same, but the plaintiff's memories were all the same. But you have the photographs that show the progress of the work that the DOB took, and you have the payment requests that show how much work was completed on such and such dates, and the court just completely disregarded those.
Thank you. Thank you all.
Thank you, Your Honor. Thank you.
People versus Matthews.
Good afternoon, Your Honor. Jose David Rodriguez Gonzalez of the Legal Aid Society for Mr. Matthews. And if I could ask for 1 minute for rebuttal, Your Honor.
Yes.
Thank you. Your Honors, the purpose of the prompt outcry exception to hearsay is, and that exception is of very limited applicability. Only the fact of a complaint, not its details, can be admitted in evidence under this exception. Here, the screenshots themselves from a text message conversation with the emojis, with the text messages, with the content was admitted. And that not only the outcry itself was admitted, but it contained.
Counselor,
yes.
do the texts detail the abuse that took place in this case, or is it more sort of a general allegation that something occurred?
The text made a specific, there was a specific statement describing one of the acts of sexual abuse, in specific sexual penetration in very explicit terms. And that is another reason why it was an error to admit these text messages under the prompt outcry exception.
Let's assume for argument's sake that it was an error. Would it? I know you would disagree with this characterization, but wouldn't it be? Could it be fair to say that actually it was harmless error?
It wasn't, Your Honor, because Mr. Matthews was first, the jury rejected in significant ways the testimony of the complainant, upon which the whole case.
He was convicted on one incident, right? There were 3 separate incidents allegedly. There was a conviction on at least one, right?
Correct. He was convicted of one incident, the only one for which the text messages were introduced in evidence as purported corroboration. For the incidents for which the text messages were not used, he was acquitted. And again, the prosecutor in in summation made reference to the text messages, so telling the jury that the complainant was so upset that she could not talk, she had to text. But the other point that we make is the judge improperly precluded the defense from cross-examining the complainant as to the reasons to fabricate which was the theory upon which the defense was defending this case, when after telling the jury from the beginning, from the opening, this complainant is lying, when it came the time for the defense to explore and show and show the jury the reasons for that claim, he was completely precluded from that, an issue that was preserved because the.
I'm sorry, counsel. This is Justice Weber. You're referring to the testimony that, in terms of fabrication, that perhaps she was mad at him because of the horrible living environment. Is that what you're referring to?
Yes, Your Honor.
But did you just say that that testimony was not admitted? I thought that the testimony was admitted. However, the judge just placed limitations on the duration of the testimony.
So the defense was going to ask the complainant about a specific dispute in the apartment that the attorney told the judge that this is to show animus between them and why the complainant is making these allegations up. But the attorney was completely precluded from cross-examining the complainant as to.
Was he precluded from cross-examining Caroline about it?
Excuse me?
Was he precluded from cross-examining asking Caroline about it?
No, but Caroline was not the main witness.
It was her apartment, wasn't it?
It is her apartment, but it was the animus.
Defense counsel didn't even think of asking her about this on direct examination.
Well, Your Honor, perhaps the defense decided it wasn't worth after the defense had been precluded from asking.
So would that not be strategy? Would that not be strategy on the part of the defense attorney? I mean, you're speculating at this point in time, but would you not also agree that that would be some strategy on the part of the defense attorney? But you continually said that he was precluded from asking these questions. As was stated, the questions could have been asked of Caroline in terms of the living conditions, in terms of some issue with the dog or with a dog. I mean, these are all things that Caroline could have been asked about.
But, Your Honor, that Mr. Matthews had the right to use cross-examination to impeach the testimony of the main witness, the one he was saying had created and fabricated the allegations. No other witness was an adequate substitute for the chance, the possibility to use cross-examination to
any other questions?
Credibility.
Counsel, any other questions for counsel? Respondent.
Good afternoon, Emily Aldridge for the People. There were no details in the text message. And conveniently, counsel.
Isn't counsel correct that at least there was a graphic reference to something, right, in one of the messages?
Her girlfriend asked her, "Did he stick it in you or something?" It was a question. It wasn't even that she said, "He stuck it in me." The question was, "Did he stick it in you or something?" And she answered in the affirmative.
So isn't that a detail?
It's certainly no more detailed than what trial counsel said that his preferred statement would have been that she relayed that she'd been raped by her uncle. So people would argue that no, it's not detailed. In fact, going to the Court of Appeals decision in Ludwig, in that case, if those allegations were not deemed explicit, those were certainly more explicit than simply answering "and he did" to her her friend's inquiry. And then related to cross-examination, the only question that the court stopped was the question of who's Brownie. There was no other limitations on questioning regarding the living conditions. And furthermore, the fact that Caroline mentioned nothing about the dog, nothing about hostile environment, nothing about it being crowded. In fact, she said the defendant and her other daughter were rarely in the apartment. All goes to underscore that there wasn't a good faith basis to even ask those to go down that line of inquiry in the first place. And if there are no questions, I rest on my brief.
Thank you.
Your Honors, if in the alternative and in the alternative to our argument, and we think that what the prosecutor just mentioned regarding the preferred way the defense would have had the evidence come in, that was said almost at the end of the trial after the text messages have already come in and responding to a hypothetical from the judge. But I want to focus the rest of my time on the alternative argument, which is that the sentence was unduly harsh. He was sentenced to the maximum of 4 years prison and 10 years post-release supervision. At the beginning of this case, just before trial, the prosecutor had offered a plea to a misdemeanor offense with which the complainant... That was in order to spare the complainant testifying, wasn't it? The complainant had, yes, before she testified, but
and the judge rejected the proposed offer. But in terms of your client now, he's completed his sentence, has he not?
He completed his prison sentence. He just started his 10 years of post-release supervision.
So at this point in time, what is it that you're asking?
We're asking for a reduction of the post-release supervision term to the minimum, which is 3 years. Mr. Matthews has no priors. He is a committed parent. There are letters from the two mothers of his child, his previous partner and his current partner, saying how great a parent he is and how committed as a parent he is. Another point, all of Mr. Matthews' conviction were premised on the complainant being less than 17 years old. And at the time of the alleged incident, the complainant was 10 years shy of turning 17.
She was also his niece, is that correct?
She was his half niece. But again, there are support letters from Mr. Matthews' mother and his sisters, the complainant's grandmother and aunts, saying how great a parent and brother and son he is, and how committed to his family, and their complete support and from his immediate family, showing the great links he had with his family and community.
Any other questions? Thank you both.
Thank you.
Luck versus O'Neill.
Good afternoon, Zach Shapiro for Appellants. Supreme Court made a fundamental error in substituting its own assessment of the medical evidence for that of the medical board. The medical board reviewed Luke's records, twice examined him itself, and ruled out the stress-related conditions of coronary artery disease and hypertension. Under this court's precedent, as well as that of the Court of Appeals, that expert opinion from the medical board is competent evidence to rebut the heart-built presumption.
Counselor?
Yes.
Counselor, a pacemaker was placed in the police officer, correct?
Yes.
Did the medical board take any position with respect to the pacemaker as to whether or not it was related to, for example, to the stress of being a police officer?
The medical board did determine that he had a heart condition. The question is what caused the heart condition. And
my question is with respect to, was the pacemaker caused, was it related to stress, the stress of being a police officer?
No, your
position on that issue.
No, Your Honor, because there was no coronary artery disease or hypertension, and under this court's precedent.
So then why was the pacemaker placed in? It was just that the doctor felt it was necessary for what reason?
Well, he had cardiomyopathy. He had heart difficulties. The question is what caused them, and here there was no coronary artery disease or hypertension. those are the stress-related conditions that are required to.
You have a presumption. You have a presumption to overcome here, don't you?
That's right, but the medical board's expert opinion is enough to rebut that presumption under the Court of Appeals opinion in Simmons, under this court's repeated opinions in Pizza, Vallis, Party Buono, Gumbricht. All of those cases are the medical board made an expert determination based on the evidence that there was no coronary artery disease or hypertension, and because of that determination that he didn't have stress-related conditions, that was enough to rebut the Hartwell presumption.
But the determination by the medical board was based on what? Petitioner presented evidence that he had hypertension, and as was stated, there was evidence presented that he had the dual chamber pacemaker inserted. So I'm not understanding how then the determination was made by the medical board that he did not have hypertension and or that there was no coronary disease if there's a pacemaker that's inserted.
Well, there's no dispute about coronary artery disease. With respect to hypertension, there was the cardiac MRI finding no left ventricular hypertrophy, which is hypertension's signature disease and a requirement for showing that he had the requisite hypertension under this court's cases, like Knorr and Pelican. And there were also repeated blood pressure readings in the normal range, as well as Luke's own report that he had no history of treatment for high blood pressure.
But didn't Dr. Sacher conclude that the stress of being a policeman carrying a gun probably caused all this? And then after the medical board made its finding, it went to the Board of Trustees, which I think is the last thing that happens, and they voted 6-6, right? And that's how it ended up becoming an Article 78.
Right. On a 6-6 vote, all you need is competent evidence, credible evidence, which the Court of Appeals has equated to the same competent evidence standard and determined that a medical board opinion is competent evidence. With respect to their
of course, there's the presumption here in this particular case.
Right, but the presumption is rebutted by competent evidence, which, as the Court of Appeals said in Bachachi, is the same thing as the regular credible evidence standard.
Did the medical board ever specifically rule out that the possibility that the heart problems were related to the stress of being a police officer?
Yes, at page 40 of the record, it determined that there was no evidence of coronary artery disease or hypertension. Those are the stress-related conditions that the medical board needs to rule out. And that was based, as I was saying, on the cardiac MRI, finding no evidence of left ventricular hypertrophy, the repeated blood pressure readings in the normal range, and his own report that he had no history of treatment for high blood pressure.
Thank you.
Thank you.
Is the respondent present?
I am, Your Honor.
Go ahead.
Mr. McEnany, Tim McEnany, may it please the court. It seems that the appellant's argument can be boiled down to three basic arguments. First, that there is no hypertensive condition. This is belied by several pages in the record, including one that refers to the medical board's own hypertensive blood pressure reading on its first exam at record 40, where they found a blood pressure of 140/90. That's the November 18, 2016 medical board report, paragraph 6, last sentence. Record 45 and 47 show Mr. Luke's cardiologist with 2 hypertensive readings. Record page 56, 59, 166. Patient does have hypertensive heart disease and appears it does fit the disability due to hypertensive heart disease. Again, his cardiologist. At record page 168, it says that he has essential hypertension. At record 140, paragraph 6, there's another hypertensive blood reading. This is a stage 1, 115/84. In the record, page 161 through 162, paragraph 5, the medical board acknowledges controlled hypertension and essential hypertension diagnoses and says nothing further about them. So clearly there is hypertension. That knocks out one leg of the stool.
Well, they're stating that it wasn't job related or stress related, the stress of the job.
Yes, but they provide no articulation of a factual basis for that assertion, especially in light of his own physician's finding that that is what caused his hypertension. The other argument that they make, the second one,
if they make that finding, do they have to articulate the basis for it?
They're required to articulate the basis for any rejection of contrary medical evidence under Meyer, the Court of Appeals holding in Meyer, which states exactly that. They failed to do that. Their second argument is that there's no left ventricular hypertrophy. That there's no evidence of this. This is clearly not correct. Record page 63 and 64, paragraph 5. Actually, first, record page 52, we have a cardiology report where it states left ventricular function is mildly depressed. Left ventricular hypertrophy is mild. That exists. The medical board at record page 63 acknowledges this finding and then never addresses it again, never states its reason for disagreeing, never provides a factual basis for rejecting that finding. Let's see. In addition, that is on record page 63 where they recognize that this was stated.
Counsel, please finish up.
Okay. They also say patient does have hypertensive heart disease in paragraph 5. The last argument is that it seems that they're saying that we didn't conclusively prove that his heart disease was caused by the stress. But as the judges here have correctly pointed out, there is no requirement that he do that once she triggers the presumption. And he clearly met that burden, as the court below believed, and correctly so. And relied upon the fact that not only does he need a pacemaker in addition to the hypertrophy of the left ventricle, but that he also could need a heart transplant in the future, according to his cardiologist. This is never disputed.
Thank you.
Clearly,
thank you both.
Hypertensive heart disease.
Thank you. Thank you both. Blue Water Realty.
Good afternoon, Your Honor. Stephen Uden for Appellant. May I request 1 minute for rebuttal?
Yes.
Thank you. Your Honor, Respondent, the salon, which was a commercial tenant, was not entitled to an offset against rent due under the lease. And the trial court award, which reflected an almost 70% offset, should be modified and increased accordingly. There are really two reasons for this. The first reason is that the correct lease clause, the repair clause under the lease, which is Article 4, expressly disallows rent offsets and limits an aggrieved tenant to pursuing an action for money damages, which it's undenied that respondents here did not pursue. The second reason is constructive eviction was not before the trial court and not preserved for appeal. So
it was never raised in their answer even, was it?
It was not. There was no affirmative defense of constructive eviction, and there was no affirmative defense of partial actual conviction, which they are arguing now in their appellate brief. So because neither defense was raised as an affirmative defense in their answer, the defenses are waived. And Judge Crane so stated explicitly on the record. She stated that constructive eviction was not framed as an issue for trial, it was not pleaded, and it's not properly before the court. So the defense was not before the court and it was not preserved for appeal. So there was no right to an offset based on constructive eviction. And turning back to the first point, the case really comes down to what is the appropriate lease clause that should govern the tenant's remedies. And the correct clause is the repairs clause. Now, the trial court deferred to prior summary judgment rulings that mistakenly applied the lease destruction and casualty clause. The judge at trial felt that her hands were tied by law of the case principles on that point. The repairs clause, which is the correct clause, does not allow for rent offsets, and as I mentioned, limits remedies to bringing an action for money damages, which could have been in the form of a counterclaim in this case, but there was no counterclaim. Looking at the looking at the evidence that was presented to the trial court, it was very clear that the repairs clause would govern and apply. the whole issue was an alleged ongoing, recurring problem with water leak. There was no proof, no argument even, of a casualty event that would trigger application of the destruction clause. And counsel, even in their appellate brief, kind of admit to that by saying that the landlord breached the lease, breached duties owed to the tenant. Well, even if that's the case, that falls squarely under the repairs clause. So there's no cogent argument for applying anything other than the repairs clause, and thus there's no entitlement to an offset. And the judge's award, which was a very low award given the amount of unpaid rent due, should be modified and increased accordingly.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, and a special good afternoon to you, Judge Friedman. It's been many years since I've seen you, since Kings County. This is the first time. And I'm glad to be here. And thank you for listening to my argument. Your Honors, this is a very simple case. I'm going to make it as easy as I can. This is a simple breach of lease case where the appellant landlord says that the defendant tenant owes rent money. But the tenant claims they shouldn't have to pay all of the rent because every time it rained, it massively flooded the space.
But I mean, I think we understand that, and I think, you know, the evidence was fairly clear. The problem is, as Mr. Uden raised in his argument, doesn't what happened here fall under paragraph 4 of the lease, the repairs clause, and not under paragraph 9 of the lease, and therefore it wasn't something unexpected or whatever. As a matter of fact, it seemed to flood every time it rained. So didn't you need to have a counterclaim or an affirmative defense for constructive and partial eviction rather than the way you proceeded along in this case?
Well, the problem that I have with that argument, Your Honor, is as follows. An affirmative defense is, yes, it's waived unless it's not affirmatively pled and it takes the party by surprise at the time of trial. Here's a case where you had, by Mr. Uden's hand himself, you had several motions. I believe there were motions for summary judgment made, and all of these issues were covered. The issues of partial actual eviction and constructive eviction, they were discussed and they were covered. Anything that happened at the trial was not a surprise, and the evidence was conformed, as far as I'm concerned, to the pleadings. But I want to address specifically what the court just said about the Article 4 issue. The Article 4 issue is a direct conflict with paragraph 9, record at page 36. Paragraph 9 clearly states, this is a lease written by the landlord. It states that if the premises are partially damaged or rendered unusable, the rent until such repair is taken care of will be a portion from the day following the casualty. Now, this is a direct conflict with Article 4. The trial judge in the motions and during the trial found the obvious.
Counselor, this is Judge Singh. How does our case law define what a casualty is?
A casualty is any type of an incident that potentially can cause someone damage. If
not unexpected incident? Isn't that a fair description of the word?
Yes, unexpected, which is what happened.
But how, as my colleague pointed out, this was occurring every time it rained. So how was that an unexpected casualty, like a fire or an earthquake or something like that?
Your Honor, when it happened for the first time, it was unexpected. The build out for this was a huge sum of money. And what happened here is that the landlord precipitated a lease that has basically two means of sustaining what it means. That has to be construed in the light most favorable to the party that didn't draft the lease, which is the tenant. So there's a potential conflict. The trial judge had the opportunity of examining the credibility and demeanor of the witnesses. She was in the best position, Your Honor, to make that discretionary decision. And I just want to touch on the legal fee issue. Of the almost $1 million that the plaintiff was seeking, they got a judgment for $131,000. There was about $800,000 that they didn't get. Who was the prevailing party? How is the landlord, who didn't get 800% of its claim, the prevailing party entitled to get legal fees? Judge Crane denied their legal fees. It was the right thing to do. And she granted an abatement or a reduction based on Article 9 of the lease. And I believe that shouldn't be overturned by this court. And I would ask the court to sustain that. And thank you for listening to me.
Thank you, Your Honors. As counsel pointed out in his argument, this is a simple breach of lease case. Well, a breach of the lease is governed by Article 4. The article says, just very briefly, it is specifically agreed that tenant shall not be entitled to any set-off or reduction of rent by reason of any failure of owner to comply with the covenants of this or any other article of the lease. It was a breach of lease. That's their remedy. The trial judge, by law of the case principles, felt her hands were tied by the erroneous summary judgment rulings which applied Article 9. But as Your Honor pointed out, there's no basis whatsoever factually to apply Article 9. There was no casualty. This was an alleged ongoing, recurring thing that happened year after year after year, all of the time. Whether that's true or not was disputed. But even if it was true, it plainly falls under the umbrella of Article 4. And there's no basis at all to apply Article 9. It's a completely different situation. It's a casualty. If you look at the cases I cited in my brief, it's fire, damage from Superstorm Sandy, a pressure valve gauge burst in one case. No case law whatsoever is out there, and they don't cite to any that would suggest that ongoing leaks and intrusions of water when it rains should fall under the casualty clause. It clearly does not apply. And just the last point real quickly is the underlying summary judgment motions have nothing to do with constructive eviction. And because it was not raised as an affirmative defense, Judge Crane recognized correctly that it was not properly before the court at trial. And thus it's not preserved for appeal.
Thank you. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor. Your Honor, if you come back to Kings County, I promise all will be forgiven. Thank you.
Thank you. Turner Construction versus Nastasi Associates.
Good afternoon, Your Honor. May it please the court, this is Meredith Paley for Appellant Nastasi and Associates. This case involves a question that the Court of Appeals and this court have previously answered even recently, but because the court below overlooked clear precedent, it's necessary that we raise this issue here again today. The question is whether a contractual provision that limits the time in which a plaintiff can bring a claim is enforceable, or the same contract includes a condition precedent that is not met within the time period and is completely outside the control of plaintiff.
Counsel, this is Judge Kern. Why should we consider the condition precedent in this case where it's clearly not the basis upon which the contractor is seeking to bring the claims?
Where it's not the basis that, for the
contractor brought an action for termination based on default. The contractor is not claiming I'm not paying the claim because I didn't get paid. That's not the allegation that's being made in this case. So why are those cases applicable then in this situation?
Well, our counterclaim isn't necessarily tied to their affirmative claims. Nastasi is owed money in part due to unprocessed change orders that were not submitted to the owners by Turner. The condition precedent applies directly to payments. Our counterclaims are for payment.
So, but you're the defendant. You're sued by Turner first. And what does Turner sue you for?
They're claiming, for breach of contract.
They're claiming your non-performance of the contract. And you've got counterclaims in which you're saying, well, you haven't paid us what you owe us under the contract. How, in the face of being served with that complaint, do you wait 2 years to put in counterclaims?
I don't really think that goes to the question of whether the contractual limitation is enforceable. In Executive Plaza, the Court of Appeals, and in Greystone, this court, they look specifically at whether the condition precedent can be met in the period, and if it can't, and especially when it's outside of our control, then the limitation is unenforceable. Whether, once you say that provision is unreasonable, unfair, and unenforceable, after that, it doesn't really matter whether it was brought immediately in 2017 or some point thereafter. The provision shouldn't be enforceable. But
you point to the pay when paid provision, but Turner did not assert that that condition precedent is the basis for non-payment of the amounts that you are now seeking.
Well, that's what they say in their papers. However, in communications between the principal of Nastasi and Turner was saying, you haven't processed our change orders. You know, you need to pay us so that we can pay these other people. And Turner responded saying, it was a senior vice president saying, we are also working on processing completed change orders so that you can bill and get paid. So I think there was an acknowledgement by Turner that they are not obligated to pay my client until they have submitted the change orders and until they have been paid by the owners.
And counsel, will discovery aid in resolving these issues as to Turner's motivation for non-payment?
Yes, I mean, I believe we haven't had an opportunity for discovery on these issues, and for that reason, I think that the dismissal was premature. It's I think
discovery uncover. What's the discovery you want, and what would uncover in terms of the arguments you're making?
Well, I would say I don't believe, I believe discovery could be helpful, but I don't believe that it's necessary. I think on the facts that we have before us, we have enough to say that this provision is unenforceable. Essentially, Turner has...
That's based on DNS restoration, which is a second department case, correct? That would be your basis for saying that.
No, Greystone, which notably, it was from this court earlier this year. It actually was entered a few days after the trial court entered its decision here. I think the trial court was wrong based on Executive Plaza and DNS construction prior to this court entering the Greystone decision.
Counsel, but the Greystone decision, that was squarely at issue, whether or not the contractor was withholding payments based on the fact that it had not received payments. So the condition precedent was actually in play, which it does not appear to be in this case. So, but just so I understand, your argument is that as a matter of law, then discovery is not relevant. As a matter of law, these kind of clauses are not enforceable under the current state of the law, no matter what the factual circumstances.
No, that's not what I'm saying. I'm saying here we've created a factual issue that it's likely that there was never a day that Nastasi could have brought claims against Turner, because we submitted change orders to Turner. They sat on those change orders, refused to submit them to the owners. So we couldn't,
Counsel, once they commenced a lawsuit against you and they said, we are not paying you under any circumstances, you've breached the contract, we are not paying you the money. Didn't you know at that point that you had to bring the claim? And even if not earlier, at that point, there's no question you knew that they were not going to be paying you. It had nothing to do with whether or not they were submitting, further requests for payment to the owner.
But had we brought the claim, even then, they still would have been within their right, pursuant to the terms of the contract, to say your claims aren't right. That's a fact, and I think that's what's problematic of the combination of these two provisions. There may have never been a day where our claims were both right.
By the picture you're presenting, would they still be in a position to say that the claims are not right?
Well,
I mean, wouldn't that follow from what you're saying?
To be honest, I can't say. The information is in Turner's possession, so I don't know whether they've been paid, and I do think discovery would be helpful on that point.
So they can still say your claims are not right. Okay, you have time in response, so let's hear from the respondent.
Thank you, Your Honors. Good afternoon. My name is Alex Saunders, law firm of Picard and Abramson for plaintiff respondent.
Counsel, this is Judge Singh. Has Turner has been paid by the owner in this case?
Yes, Your Honor. But
and when was Turner paid for by the owner?
That is not honestly relevant to the issue.
I understand. Respectfully, Counselor, I understand you believe it's not relevant to your self-serving assertion that it doesn't matter, but it's relevant to me. So when was Turner paid by the owner?
Well, we're talking about 5 different projects. We're talking about records which were included with our document productions. There's going to be different ways of looking at that question. One way of looking at the question is that the any amounts due to Nastasi or NNA, the subcontractor, were canceled out by the excessive indebtedness incurred by NNA, which is what precipitated.
So based on your action. But that's not answering my question. Again, it's a simple question.
Well, the right to receive payment, the obligation of Turner to pay NNA flows
is conditioned
directly
on you getting money from the owner. So did the owner pay you for these 5 projects?
Yes.
And is that something we can decide on a pleadings motion?
That's again, there's no question that at the time of the filing of Turner's complaint in April of 2017, that there were no conditions precedent at that point. Turner unequivocally stated with that complaint, we're not paying you another cent. There was no question at that time. The clock was certainly ticking, and NNA still.
And counsel for appellant says that you could have said their claim was not ripe. Could you have said that at that point?
Well, it's hard to deal with hypotheticals, Your Honor. We certainly do know that those counterclaims were not asserted until more than 2 years after the filing of Turner's complaint. In fact,
when you filed your complaint, this is not a hostile question. When you filed your complaint, could you have said that Nastasi's claims were not ripe?
No, Your Honor, because we are not. The pay when paid provision simply wasn't in play. Turner never asserted as a defense to pay.
So in other words, you decided unilaterally not to invoke the condition precedent, correct?
Well, Your Honor, that's the crux of these cases, is that there exists a ripened controversy. At the point when Turner said, nope, we're not paying you anymore, you now have a ripened legal controversy. The clock is ticking at that point.
And so again, if payment had been demanded at that time, could you have taken the position that we are not paying you because we haven't been paid by the owner on XYZ project? Not that you didn't do it. Could you have taken that position?
Obviously, these are hypothetical issues. From Turner's viewpoint, the rights, NNA's contract rights were terminated on a date certain. Also, at that time,
when you filed your complaint, you were unequivocally indicating to Nastasi that you're not paying them anything.
That's correct. At that point, there's no question.
When do you think that the 1 year the claim accrued? When do you think that the 1 year started to run? Was it from the date that you filed the notice of termination, or was it from the date that you filed the complaint against Nastasi, or some other time?
It was 1 year from the notice of termination for cause. At that point, Turner.
So you didn't even file your complaint until after that. So it was like too late even then, is what you're saying, because the notice of termination was in 2015, I believe, and your action didn't even start till 2017.
And at what point did Nastasi know, in fact, that the basis of your suit was we're not paying you irrespective of what happened with the owner? Was it the time of your notice of default, or at the time you brought your lawsuit?
For purposes of this motion, I'm not sure that it matters, Your Honor. It's, again, the counterclaims were filed more than 2 years after Turner filed its complaint. That's well beyond the time under any formulation.
Counsel, this is Judge Karn. Let me ask you a question. So once you served them with the notices of termination based on default, could you then have also taken the position that you weren't going to pay them because you had not been paid? Or were you bound by your position that the reason you were not paying them was based on their default?
At that point, the decision was taken to terminate NNA's contract rights, and it was also known at that point that there were going to be no more contract payments. to NNA, that it wasn't, there was no waiting for the owner to do anything in terms of paying any payment requests.
No.
At that point, it was
I mean, whatever it was, by the time you filed your complaint, you even if the period doesn't, the 1 year period doesn't run until the time you filed your complaint, by the time you filed your complaint, you had made unequivocally clear that you're not paying them.
That's correct, Your Honor.
Is there a case that supports this position that you're taking? I mean, for example, Second Department DNS restoration, does that support your position?
Well, yes, it does. The cases DNS restoration, Greystone are clearly distinguishable. In those cases, the subcontractor had finished its work, and the contractor said in response, well, wait, I have to wait to receive payment from the owner, therefore invoking the protections of the pay when paid. The contractor was forestalling payment to the subcontractor based on receiving payment from the owner. That simply didn't occur here. Here, NNA was terminated for cause, and the clock started ticking on any claims at that point. There was no waiting for the owner to do anything under these circumstances.
Thank you.
Thank you, Your Honors.
Appellant, you have a minute.
Thank you. I first want to mention that the contract expressly allows or requires that Turner still pay Nastasi after a notice of default for any work done up until that point. So a notice of default doesn't instantly trigger that we would know they don't intend to fulfill their contractual obligations. Further, it's not.
Did you think they were going to pay you after they served you with the complaint?
Yes. The complaint, did you say?
Yeah. You thought they were going to pay you after they served you with the summons and complaint?
I don't know, but I don't think that goes to the legal question in all of these cases as to whether that provision is enforceable.
Whether it is, because maybe we can argue about what someone thought before when they served you with the notice of termination, but by the time they served you the notice of complaint, by the time they served you with the summons and complaint, there was no doubt about what was happening here. And that contract provides that you have just 1 year to file suit.
Yeah, but the contract also provides that there is an express condition precedent, and whether Mr. Saunders says that they never intended to enforce that or they weren't going to use that, they could have. And if you look at this contract, whether they served a complaint or not, we may not have had a right claim. Whether he's
have any need to rely on that, of course, because they've already served you by starting an action with unequivocal notification that we're not paying you.
But it could be a defense to the claim.
Anyhow, thank you both.
Well, I think, sorry, but in the case
I wanted to say something else. Go ahead.
And in the case of Dijasari, there were 20 payments made, or 20 invoices from the subcontractor to the general contractor. The general contractor paid the first 15, stopped paying on the 16th. There's no indication, at least from the decision, that the general contractor was relying on the condition precedent to not make the payment. So I don't even know that always is the case. Finally, I do think the emails show that the general contractor was saying, we will try to process this so you can get paid. So I don't think it's the case here. We don't.
And are those emails in the record?
They are. And I believe we cite to most of them in our papers, but A242 is one. There are communications A196, A186, A198 through A200, where the parties are going back and forth about the unprocessed change orders, which I think is a recognition that is how this contract works. And that they weren't paying, they still have to process the change orders.
Thank you. Thank you both.
Thank you.
Commissioner of DSS.
For Appellant, New York Presbyterian Hospital, Stuart Perry, introducing Franklin Solomon.
Good afternoon, Your Honor. Franklin Solomon for New York Presbyterian Hospital. I'd like to reserve 1 minute of my 4 minutes of time for rebuttal.
Go ahead.
Thank you, Judge. Your Honor, we're here because the hospital has been ordered to pay as a judgment a sum certain that was based on nothing but the say-so of the Department of Social Services. There was never been a factual determination of the scope and the amount of the DSS claim, and the hospital has never had an opportunity to present evidence and argument to a finder of fact regarding the amount of any obligation.
Counsel, why does that matter?
Well, it's important because the Medicaid claim here includes millions of dollars for treatment that was necessitated by a genetic defect.
But you agreed, and I know we've gone through a number of appeals on this case, you agreed to assume full responsibility for any monies which are ultimately found to be due to Medicaid. Full responsibility means just that.
Except for the fact that, and that's really the issue here. What does full responsibility mean in the context of this case?
I mean, counsel, that issue, this is at least your third bite of the apple on this issue, and you've lost it twice before. I don't know why you think the decision would change now. I think I would like you to address the issue of what the interest rate and what you have to pay is.
All right, regardless of what we have to pay, the interest rate as calculated by the court using the general rate of the CPLR 5004 is incorrect. There is a specific statute that governs Medicaid overpayment actions and sets the amount of interest due at the prime rate plus 2%. And because there is a specific statute that sets that rate, the general default rate of the CPLR is not applicable.
And at this point in time, so the statutory rate would be 9%. What is the interest rate, just as a matter of information? What is that alternative interest rate at this point?
I am not sure what it is, what the prime rate is today, but up to the date of judgment, it had been in the, we had set out in our papers on in the initial brief.
Well, let me help you out. I gather what you're saying, it's significantly less than the 9%.
Yes, it is. It's varied between 5.5% and 3.25% over the years. So so in total, it adds up to about a little more than $785,000 in difference in the interest calculation, and that's a significant sum in the context of this case, certainly.
Any other questions for counsel? Thank you. Respondent.
Good afternoon, Your Honors. Jesse Townsend for the Respondent. Your Honors, just speaking briefly on the merits, we would contend that the issue of the merits, the scope of liability, has been well determined by this court's prior decisions and by the plain language of the contract. So unless Your Honors have questions about that issue, I'll go to the interest issue. First, the hospital never objected to the application of the statutory interest, but even though it had the opportunity to do so when the commissioner moved for judgment, for the entry of judgment in Supreme Court. And this court doesn't allow entirely new issues to be presented on appeal for the first time on appeal. But even if this issue were preserved, the regulation to which the hospital points to does not apply for at least 3 reasons. The first is that the regulatory part that's being cited to, Part 518, applies to actions brought by the State Department of Social Services, not the City Department of Social Services. You can see that because Section 518.2 incorporates definitions from Part 515. Part 515.1b5 defines department as the State Department of Social Services. There's also a further reference to an additional set of definitions incorporated from Part 504, and Section 504.1d6 defines department as either the state DSS or local departments, to the extent local departments have been authorized to enroll providers. And as a factual matter, that's just not the case for the local department that brought this case. And just factually speaking, cases about provider overpayments are brought by the state, or in some cases, the U.S. Attorney's Office, not by the City Department of Social Services. Secondly, the regulatory part referred to defines overpayments as any amount not authorized to be paid under the medical assistance program. You see that in Section 518.1. Is the rules of Medicaid, something that was not authorized by the rules of Medicaid. And we've never argued that the hospital was not authorized to bill under Medicaid. The issue, the authorization or the contractual issue, not the application of the Medicaid rules to this particular type of care. And relatedly, this part describes recovery of overpayment for inappropriate, improper, unnecessary, or excessive care. And that's in section 518.3b. And again, at no point has the department said that the hospital provided excessive care or billed Medicaid for care that went to another patient. That's not this case. And if it were one of those circumstances, that's when the interest rate would apply. But essentially, this is a contract case, and the fact that the hospital happens to also be a provider is essentially incidental to its liability in the circumstance, and that's why the statutory interest rate applies as opposed to the interest rate defined.
Counsel, why is this a contract case? Why isn't this a case that you're getting reimbursement because you provided the funds? Why does it turn into a contract case?
It provides in a contract case, Your Honor, because we sued with regard to the hospital, we sued to enforce the contractual agreement to assume full responsibility for any
third-party beneficiary of that contract, but you only had a right to get the payment because you did provide the funds for the medical services. So your right to payment doesn't come from the contract, it comes from the fact that you paid for the services.
I would say first the fact that we paid for the services, and then the contract specified that the hospital would assume full responsibility for repaying those monies. It's those things together, and our specific claim against the hospital for which we received summary judgment was a breach of contract claim, Your Honor.
Thank you. Any other questions for counsel? Mr. Solomon?
Just briefly in rebuttal, Your Honor. The argument that...
Just on the merits, by the way, the Court of Appeals denied leave on the underlying merits issue, right?
I understand that, Judge, and with all candor, I think that the court got it wrong because I think that if you look at the facts of the record, it clearly limits the liability of the hospital in the context of the settlement agreement.
You're certainly entitled to that opinion, so.
I understand that's at variance with yours. So.
You have a right to have that opinion, and so no problem with that.
With respect to the argument on the interest rate, first of all, DSS never raised in any of their briefs that this statute is applicable only to state actions rather than to city actions. So I think they ought to be foreclosed from making that argument here. I haven't had a chance to research or address that. Number two, this is clearly
that argument's not preserved.
That our argument is not preserved?
That argument by the respondent is not preserved.
All right, thank you. With respect to this claim, overall, this is clearly an action for recovery of an overpayment of Medicaid expenses. It doesn't matter under 518 whether this is characterized as fraud, as abuse, as improper billing, as a contract claim. Absolutely, none of that matters. All of those form the basis for an action by the department under that statute with the appropriate interest rate. It can be done as an administrative proceeding. It can be done as an action in the civil part. The reason that this action was brought in the civil part was because in addition to the hospital as a defendant, DSS had also named the SNT trustees and the estate of Merrick Lee because they clearly thought that those parties also had liability to the department for reimbursement of Medicaid expenses. And it wasn't solely the hospital's obligation. They are not would not have been subject to the administrative process that could also be used under 518. So the department was actually left with no alternative but to use a civil action to bring all the parties into the case. So the general civil rate, the default rate of the CPLR doesn't apply because there is a specific rate set by statute for this kind of a recovery action.
Thank you. Thank you both. People versus Rodriguez.
Good afternoon, Your Honor. May I proceed?
Go ahead.
May it please the court, Taylor Poore with the Office of the Appellate Defender on behalf of Mr. Rodriguez. The officers who arrested Mr. Rodriguez for robbery did not have probable cause. What they saw was two men fighting, one of whom, the complainant, tackled Mr. Rodriguez onto the hood of their police car. The complainant was clearly trying to tell the officers something, but they couldn't understand what he was saying because of a language barrier. And next, a stranger jumped in and told the officers Mr. Rosario had been robbed at knife point and that the robber had chased him to the scene.
Counsel?
Yes.
Counsel, this is Judge Singh. Can probable cause be established through a hearsay?
Yes, at a suppression hearing, absolutely. But every level of hearsay must be supplied by indicia of reliability.
Why? I'm sorry. Go ahead.
You go ahead.
Why is the bystander's translation not reliable?
First of all, Your Honor, I don't think that the officers had any reason to believe that this was a translation. They never had any reason to think that this bystander was a Spanish speaker, whether the bystander...
Why didn't they have any reason to think he's a Spanish speaker? Wasn't he translating for the victim? Wasn't he telling the police what the victim was saying?
We have no reason to believe that, Your Honor. In fact, one of the very first pieces of information that the bystander gave the officers was in direct contradiction to what they had just witnessed. So if I would urge the court to look specifically at page 14 of the hearing.
What was the contradiction, counsel, because of the improper pronoun?
Not necessarily. So maybe this is what you're getting at, Judge, but the contradiction was that the bystander told the officers that Mr. Rosario had been robbed at knife point and that Mr. Rodriguez had chased him onto that location. But in fact, what the officers had just seen was Mr. Rosario chasing Mr. Rodriguez and tackling him onto the hood of their police car.
So counsel, why would we not look at the totality of the circumstances? I mean, we have two individuals who are fighting, which the evidence clearly showed. They're fighting. They're actually fighting onto the hood or the patrol car, right, where the police officers are standing right there. The complainant is making these gestures and pointing at the defendant, right? And then we have this other individual, and the complainant is also speaking in Spanish, which the officers do not understand. And then we have another individual who is a bystander who is stating and telling the officers what the complainant is saying. So under the totality of the circumstances, why would that not be enough for the officers to conclude that the defendant had just engaged in some illegal activity towards the complainant?
I actually think the totality of the circumstances here, Judge, showed a fight that could just as easily have been interpreted as Mr. Rosario attempting to rob Mr. Rodriguez, since there was clearly money of some kind involved. He was the one who had tackled Mr. Rodriguez.
I'm sorry, didn't the money fall to the ground at some point? And was there an observation where it came from?
At least some of the money fell to the ground, yes.
And where did it come from?
The officers testified that it came from Mr. Rodriguez's pocket. But again, I think...
Go ahead. I'm sorry, go ahead.
Wasn't the fact that that this bystander came along, so you're suggesting that there could be an implication that he came along and he just made up the story, like it, he just said whatever he wanted to rather than accurately interpreting what was said. And when this all happened very quickly, isn't there at least an indicia that he would have been interpreting and not coming to the police officers and just making up a fantasy because he had nothing else to do at the moment? I mean, well,
again, sorry.
Go ahead.
Again, this was the information that came from the bystander was incredibly minimal, and half of that information was demonstrably incorrect. So I think the assumption that the bystander
how is it demonstratively incorrect?
Because the bystander had told the officers that Mr. Rosario had been chased onto that location, whereas the officers could see that Mr. Rodriguez had been the one who was chased and then tackled onto the police vehicle. But I think that under
so that
the
makes
circumstances,
it demonstrably incorrect that Mr. Rodriguez was the one who was engaged in the illegal conduct towards the complainant?
It makes it demonstrably incorrect that the bystander had reliable information that the officers could use to contribute to probable cause analysis. Now, I think that
it seems like it's it seems like it's the fluid after effects of a crime having been committed, and with the help of the interpreter, they figure out what's going on, or think they figure out what's going on.
I agree that it was a fluid situation. It was a tense situation. Things were moving quickly, but nobody was trying to flee the scene, and that was very clear. I think that we would absolutely acknowledge that the officers had reason to freeze the action, call a language service to even ascertain. There was no evidence until Mr. Rosario later gave his statement that he was even speaking Spanish at all. These officers assumed he was speaking Spanish, but neither of them spoke or understood Spanish. So that was yet another assumption that was not actually confirmed until after the arrest. So
if you don't speak Spanish, or if you don't speak Spanish, you may understand certain words in Spanish or in any other language. So I'm not sure how you can conclude, therefore, because the officers did not necessarily speak Spanish, that they could not tell the language that both the complainant as well as the bystander were in fact speaking.
The bystander never gave any additional details, any details of any kind to suggest that he or she actually spoke Spanish. I agree with Justice Weber's comment that some people may be able to speak a few words of Spanish. That was not what the officers testified to in this case. The officers testified that they could not understand Spanish. They could have called a language service. They could have called the officer who later ended up taking Mr. Rosario's statement at the station, who was a fluent Spanish speaker. They did none of these things, and they had a complete vacuum of information that did not have help us.
Thank you.
Felicia Yancey for the people. Good afternoon, Your Honors. May it please the court. In this case, as Justice Weber stated, this was based on the totality of the circumstances. As you all know, street encounters are dynamic situations that often escalate as the events unfold. And here you had the police officers observe the victim, Mr. Rosario, pursue and tackle the defendant upon the top of their hood. They then see that Mr. Rosario, the victim, is excited and upset, and he's gesturing and identifying the defendant in, and I submit, Spanish. And though they were not fluent in Spanish, the common sense suggests that they identified that was the language. Then you have the unidentified bystander translate and provide information that the victim told. The translator is saying the victim is saying that the defendant robbed the victim of $200 at knife point. And then when the two parties are separated, you have the exact amount, you have a wad of money that falls from the defendant's pocket, say perhaps one bill, and it's the exact amount that the bystander informed the police officer the victim stated was stolen from him. So with the totality of the circumstances, there's no doubt that there was probable cause established. What defense counsel would like you to do is to take a snapshot, freeze it a moment in time, and in isolation, and just look at the bystander statement. Ignore the victim upset and pointing, ignore the police officer's personal observation that the victim was chasing the defendant, and ignore the $200 falling from the defendant's pocket. Instead, they want you to believe that the victim somehow decided to assault the defendant in front of the police officer, which they were sitting in clearly a marked RMP, and then commit that crime. I mean, that just belies common sense. And considering all of the additional, circumstances that occurred at the time, the reasonable conclusion for them to draw is that the defendant had robbed the victim of the $200, and therefore they had probable cause to arrest the defendant.
Thank you.
Thank you.
Any questions for counsel? Appellant?
Thank you, Your Honor. Just to correct a few pieces of the record. First, the bystander never said anything about $200 having been taken. That was something that was never part of the record, and it was the officers discovered it later in their investigation. Again, after the arrest and once Mr. Rosario was back at the station giving his statement. Additionally, the complainant in this case, Mr. Rosario, did assault Mr. Rodriguez in view of the police officers. That was what they testified to, and that was in the record. Again, both the hearing court and now respondent fall into the same trap when they list factors contributing to probable cause that were unknown to the officers until after the arrest, like the amount of money that was in question, or the fact that Mr. Rosario spoke Spanish, or that the bystander spoke Spanish. The officers here had many options for continuing to investigate and for gaining additional information about this admittedly very quick moving situation. They did none of those things. And so for the reasons that I've already mentioned and those in our brief, Mr. Rodriguez's suppression motion should be granted. And because he has now completely finished his sentence, the appropriate remedy is that the indictment be dismissed.
Thank you. Thank you. Thank you both.
Thank you.
Sumpus 1105 versus 1109 Lexington Avenue.
Yes, Mikhail Schenker for respondent.
The appellant's not present.
I see someone here named Salil Remote 5. That appears to be the general counsel for the appellant, but they're not for some reason speaking up.
I did notice that appear on the screen.
I think it says they're in the lobby and they're waiting to get admitted. I'm not sure what to do.
Well,
That's above my pay grade.
I know that our tech people. I know that our tech people who are on this know what to do. So, is the appellant present on Sumpus?
Should we leave it till later?
Schenker, why don't I call? I'm going to call the next case and then come back to you. Okay.
Okay, no problem.
Let's see if we can. Of course, I had seen that appearing on the screen about being in the lobby. So we'll take Ditech and then we'll come back to Sumpus. Ditech Financial. Ditech Financial.
Good afternoon, Your Honor. Can you hear me?
Yes.
Oh, yes. Good afternoon, Your Honor. Adam Swanson for the appellant Ditech Financial, and I apologize for our technical difficulties today.
We can hear you. We can hear you loud and clear. So go ahead.
I'm sorry. You can hear me good. Yes.
We can hear you loud and clear. So go ahead.
Excellent. This appeal presents the court with three substantial issues of New York consumer mortgage law. Underlying each of those three issues.
But actually, one of the issues which is percolating in this case relates to how you accelerate and decelerate, how a bank accelerates and decelerates a mortgage. And as I assume you're aware, there are 3 appeals pending at the Court of Appeals in cases which involve that issue. Wouldn't a sensible exercise of discretion indicate that we should wait to see what the Court of Appeals has to say about those cases before tackling your case?
That would, Your Honor, and Your Honor is discussing the Freedom Mortgage versus Engel and the Nidal case, which, yes, they're set for argument in January in the Court of Appeals. But there is a distinction that hasn't been addressed and may not be addressed by the Court of Appeals, and that is the question in those cases is whether or not making a voluntary discontinuance is an affirmative act of revocation. In other words, the focus is on the action of the party. What we're arguing is under the case of Loeb versus Willis, that the actual discontinuance itself is what nullifies any election to accelerate that's contained in the complaint.
Counsel, this is Judge Kern. There's a lot of clear precedent, though, from the First Department that's very clear that says exactly the opposite. So just based on the precedent of the First Department as it now exists, I think we've held very explicitly that a voluntary discontinuance is not enough to deaccelerate.
Those cases, Your Honor, City Mortgage versus Dalal and U.S. Bank versus the Board of Managers, those cases focus on what the Court of Appeals is going to focus on, and that is what the effect of making that motion is and the actions of the plaintiff. The
Second Department has held otherwise.
The Second Department has held that the affirmative act itself is not an act of revocation. The question of what the effect of the court's discontinuance is a question addressed in Loeb versus Willis and Foster versus the New York Hudson Railroad. And in those cases, what this court has said is that once the action is discontinued, it's as if it had never been. Anything done by that action.
What you didn't really address Judge Kern's point, which I agree with, because I think I've been on some of those cases very recently, that the voluntary discontinuance of a foreclosure action was insufficient to constitute an affirmative act of revocation of the mortgage acceleration. There's been some Wells Fargo cases in 2020 from our court that say that. So I'm not sure where the cases are that you're talking about, but I think we have some cases that make that pretty clear, that point.
So that's correct, Justice Kapnick. You were on the panel that ruled on City Mortgage versus Dalal, and that focused on what the actions of the lender amounted to. But the question of what the effect of the actual discontinuance itself means, that's a different question. And what
Counsel,
we've
addressed that issue too, though. We have specifically held that the court voluntary discontinuing the action does not have the effect of deaccelerating the loan. We've held that.
The wording in the U.S. Bank versus Board of Managers case is that it's not a sufficient act of revocation, so act on the part of the mortgagee. But to Justice Friedman's point, this is going to be an issue that's resolved in the Court of Appeals in January. So to the extent this court seeks to rule on that issue, waiting for the Court of Appeals to weigh in would certainly be a provident exercise of discretion. And we would affirmatively ask the court to do that. The other two issues is when did that acceleration actually happen? And the actual happening of the acceleration involves two essential features of an acceleration. The first being that the lender is obligated to accept nothing less than full debt, and the second that the borrower is entitled to pay nothing less than the full debt. And those two features of an acceleration under the mortgage at issue here don't present until judgment enters. And the Court of Appeals in Albertina versus Rosborough explains that the terms of the mortgage must control when this acceleration happens. And what happened in Albertina was the plaintiff commenced an action to foreclose its mortgage 3 days after the borrower had defaulted on a payment of principal. And then 3 days after that action had been commenced, the borrower showed up and said, I have the money to cure my default. I have the money to pay that installment. And the lender refused the payment. When the lender refused the payment, it said, we've accelerated the loan and you cannot pay less than full debt. And the Court of Appeals agreed and said because the lender had accelerated and the loan was in a state of acceleration, the borrower had no right to pay something less than the full accelerated debt. But looking at the terms of our mortgage here, that would not be the outcome. The outcome here would be that the borrower could pay less than the full debt because the borrower has a right to cure the default under the terms of the mortgage. The Albertina case says you must look specifically at the terms of the mortgage and discusses what an acceleration is. And it's a remedy. And it's a remedy like every other option contract. The remedy must first be elected and then second become manifest. So under the circumstances here, when that election is made, the actual acceleration happens later. They're two different events. One is the making of the election, which is the statement in the complaint that the lender has elected to accelerate. And the second is when those two features of an acceleration present. And that is when judgment enters because the lender's right to accelerate is qualified here by the borrower's right to cure the default.
Counsel, hasn't that position already been rejected by the second, third, and fourth department?
It has been rejected by the second, third, and fourth department, Your Honor, that's right. And what they focused on were conditions precedent and constraints on the lender's right, which are different and distinct from the question of what does an acceleration mean and how is that defined under New York law. We are not arguing that there is a condition precedent to our right to accelerate. The question is, what does acceleration mean under New York law? And here, the respondent has shown the court the consequences of a ruling that the complaint filing accelerates the loan. At page 30 of their brief, the respondent explains that once Ditech filed its complaint, the borrower no longer could pay less than full debt. And that is the consequence, because that undercuts the reason that the right to cure, paragraph 19 of the mortgage exists, is that consumer borrowers are supposed to have the right to cure until the moment the judgment enters. And that's why acceleration doesn't happen until that moment.
Thank you, Counselor. Thank you.
Thank you, Your Honor.
Good afternoon, Paula Miller for the respondent. May it please the court. Initially, two of the points that were raised by the appellant in their brief, which is the discontinuance argument and the acceleration argument, those are not the scope of this appellate review. In the underlying motion, the plaintiff, by design, rejected those, not rejected, but failed to even make those arguments. And the reason I say it was by design was because the plaintiff was so convicted of what we're calling this McPherson argument, that the acceleration could not exist until the entry of judgment, that they didn't bother to take it to the next step to see if the discontinuance effectuated a deacceleration or to even address the acceleration letter. So this appeal is absolutely limited to only what we've identified as the McPherson argument, which, as Judge Kern has mentioned, has been across the board. It's been rejected by every department. It's also been rejected by Judge Whalen, in fact, acknowledging in recent decisions, he's the originator of that theory, that it has been rejected. And so what by the court suggesting that you will wait and hold this case in abeyance until the Court of Appeals considers, for example, the Engel case that's up there, a Naidu case on the discontinuance argument, I think is prejudicial to my client, because this plaintiff in this particular case was given an opportunity to make those arguments down on appeal, and they failed, down in the lower court, they failed to do it. And when McPherson was getting tossed out all over the place, they've now decided that they want to bring those arguments up. And they now have even suggested that let's wait to see what the Court of Appeals has to say on this. What is relevant to apply right now is what is the applicable law in the First Department today when we are making this argument. And the discontinuance, clearly, as most of the panel has sat on these cases, the Ferrado case, the Liebert case, the Dalal case, all of those cases clearly show that the discontinuance in and of itself is not an affirmative act of revocation. That is the state of the law in the First Department today, and that is what should be applied to my client today. To allow this plaintiff, who was so steadfast in this McPherson argument down below, to try to come in through the back door, bring it in on appeal, and now say that we should even wait until the Court of Appeals decides this, is extremely prejudicial to my client. And so for those reasons, I think that the scope of this appeal does need to be limited to the McPherson argument. And as I said, it's been rejected across the board. The discontinuance argument, again, there's no new spin on that. And likewise, the acceleration argument, which again, the First Department, clear on that too, Vargas, Royal Blue, those are all well established in the Second Department, and this plaintiff that ship has sailed, and they should not have a further opportunity to now bring these up for the first time on appeal.
Vargas' appeal is pending on Vargas at the Court of Appeals.
Yes,
Vargas,
Royal
the Court
Blue.
of Appeals, the Court of Appeals granted leave in Vargas.
They did, but they did not in Royal Blue, which was the same issue. And again, these issues were not.
Sorry, this is Judge Kern. Weren't you the one down below there who made the argument about that the prior action caused, the prior voluntary discontinuance caused the deacceleration? Wasn't that your argument? Which
No,
was
quite to the contrary. We in establishing that the motion was a defendant's 3211A5 motion. So in establishing our prima facie case that the claims were time barred, we established our acceleration through the acceleration letter. We established the acceleration through the commencement of the 2008 action. And at that point, we indicated in our motion down below that the fact that there had been a discontinuance did not effectuate a deacceleration. So we laid it out on the table.
It was addressed below and decided below. Why wouldn't it be part of the appeal? I'm just not sure I understand your argument.
Because even though we did address it as part of our case in chief, when the burden was transferred over to the plaintiff on a dismissal motion, the plaintiff then has the burden to show a triable issue on why the statute of limitations had not run. And that record is limited only to the McPherson argument. And so the point, this is more from a procedural posture that this plaintiff should not benefit by having, in essence, defaulted on those arguments down below, bringing them up now for the first time on the appeal, and then further asking this court to apply a law that may or may not be changed by the Court of Appeals in the future.
Any further questions for counsel? Thank you.
Thank you.
Your Honors, if I could just briefly address the issue of waiver down below, and as Justice Kern pointed out, Justice Bluth in fact ruled upon this issue, and it was all a part of the same motion which we opposed. And since the ruling below actually reached the issue, this court can and should review it. Now, what Respondent's counsel is trying to do is analogize to a situation where there might be a couple of different branches of the motion seeking different forms of relief, but that was not true here. So no branch of this motion was not opposed. The motion was opposed in its entirety, and Justice Bluth actually did reach that as the issue of whether or not the voluntary discontinuance deaccelerated the loan, and this court can reach it. And in fact, as Justice Friedman pointed out, the Court of Appeals may just change that law in its entirety for the entire state in just a few months. So waiting for a decision from the Court of Appeals will not be prejudicial to anybody, because as the court is aware, these issues of law are in flux and they are changing. So waiting for a January or February decision from the Court of Appeals would not be prejudicial to a real estate investor, not a borrower, not a consumer borrower, but a real estate investor, which is what Rector 7.0 is.
I obviously can't be sure where they're going with it, but the Court of Appeals granted leave on 3 of these cases. Anyhow, thank you both.
Thank you, Your Honor.
Sumpers versus 1109 Lexington Avenue. Has the appellant's attorney joined us? Counsel for 1109 Lexington Avenue. Mr. Schenker, right? You're the respondent?
Correct, Your Honor.
Yeah, I know that our IT people have been trying to be in touch with counsel, and he's been having technical difficulties. So I will ask you that I'm going to call the case again. Let me go to McCullough versus One Bryant.
Okay. Your Honor.
I'm sorry. Thank you. So we'll come back to Sumpus, and let's go to McCullough versus One Bryant Park.
Good afternoon, Your Honors. Anthony DiStefano for the defendants' appellants, One Bryant Park and Tishman Construction Corp. I'm going to begin my argument by explaining what I am not arguing here today. I'm not arguing that the labor law 241 sub 6 liability against my client should be dismissed. And I'm not arguing that the finding of active fault against my client, Tishman Construction Corp., should be dismissed. Instead, what I'm arguing is that the jury's apportionments of fault to the plaintiff and to co-defendant component assembly systems are simply too low. In this case, the jury found 5% against the plaintiff and 5% against component. With regard to the plaintiff, it is unquestioned that the plaintiff acknowledged in his testimony that he bore the primary responsibility for his own safety. He further admitted that he could have readily seen the condition that he fell into had he simply looked for it, that the lighting was good, and that the only thing that obstructed his view of the hole into which he stepped was a plywood threshold that was...
Well, but that was the big thing, because the plywood threshold was fairly high and he wasn't expecting there to be a hole in there, and he had never been in that room before. And so all those things, the jury heard all that.
Yes, Your Honor. The jury also heard that he simply taken a half second to look, acknowledging again that he understood that he bore the primary responsibility for his own safety in this regard, a half second to look and he would have seen the condition. And he had predominantly worked on this floor before, and he had seen other holes in the floor before.
But wasn't that hole supposed to be covered by a plywood? I mean, the holes of that type were supposed to be covered. So he really he didn't think he was going to step into that room and that work had been done in the past and find a hole like he did.
But he did testify that he had seen an open hole in the floor in the past, and that he had actually called the contractor's attention to that to come and cover that hole. So it's not even as though he relied on the fact that the hole was covered to blindly step into the room. It's that he just simply disregarded that there was the possibility that there was a hole there, and he didn't look out. And again, if the threshold is so high that it obstructed his view of the entrance into the room, then that just heightened his obligation to just take a half a second and look on the other side. And again, I'm not saying that that my clients were not at fault, or that the claim of 241 sub 6 should be dismissed. I'm simply saying that under the cases that we've cited in our brief, where this court has found in the past from 40 to 70% responsibility on a plaintiff who has missed conditions like this. And again, I'm not disputing that there's an obstruction there, but when you look at the cases, the range of 40 to 70%, when compared to the only 5% that we have here, it's simply too low. And the same with respect to component. Component, for them to have 5% responsibility, with all due respect, the argument that they had was that the hole ceased to be a hole because it had a pipe inserted into it. But, it clearly was still a hole in the floor. And the witness for the contractor testified that that is the type of hole that they would have been obligated to protect. The dispute was over whether or not they would have responsibility to continue to walk around the construction site and make sure that the holes were protected. And I would turn the court to the contract, where it specifically says that their obligation maintained throughout the course of construction. And here, clearly, construction was still ongoing. So for that reason, the fact that they did have continuing responsibility for this makes the finding of 5% against them too low as well. And as a further point to that, one of the things that's really interesting is that this court previously determined that the reason that component could be held liable is because of its contractual responsibilities to maintain protection. But the jury, for some inexplicable reason, found that component's negligence, which again was 5%, did not arise out of its contract. Those two findings are simply irreconcilable. So at a minimum, the finding that component was not negligent in the performance of his contract needs to be set aside. And the answer to that question answered yes, of course. The final point that I wanted to make on liability, Your Honors, is that my client, One Bryan Park, is the owner of the property, and there is absolutely no indication in the record anywhere throughout the trial that One Bryan Park had any awareness of this condition. They were lumped together for purposes of the labor law 241 sub 6 liability, which again, I'm not disputing. All I'm saying is that as to active negligence, One Bryan Park could not be found actively at fault for this accident.
Did the jury make any determination about that, whether or not One Bryan Park was just being held vicariously liable, or what? I mean, under the negligence section, what do you think the jury found?
I think the jury was asked the question, One Bryant Park / Tishman, and the jury answered yes, that they were.
So how did the jury a chance to differentiate between the two because they were slashed together? How could the jury have broken out negligence where they were slashed together? And the record is that you consented to them being slashed together. So how can you possibly argue now that that was inappropriate in any way?
Because we consented for purposes of vicarious liability. It was in direct response to counsel for a component saying it's with regard to vicarious liability. We subsequently moved for a directed verdict on the issue of negligence, and it was not denied because of the merits. It was denied because the judge said that it was too late. Number one, there was no notice of it, which that's not my understanding of trial procedure, but put that aside. Number two is that the court said that we lumped One Bryant together with Tishman throughout the trial, which is not true. It was very clear throughout the trial that they were two separate defendants. And in fact, the plaintiff specifically said that it was Tishman who was in charge of the project. It was Tishman who ran the job. They had nothing to do with One Bryant Park. So for that reason, there was never any evidence of negligence against One Bryant Park. So there could be no basis upon which the jury to lump the two of the defendants together.
Did the jury find any proof of negligence against Tishman? I mean, did they find direct? Yes, they found.
Yes, they did.
But how did that get divided up if you were both slashed together, so to speak?
Yes, it should never have been divided up because they never should have been asked to apportion fault to One Bryant Park. And that's why the case that we cite in our brief was Salamoni versus Wincalf. This is this court from 1998, 249 AD 2nd. And in a situation involving 241 sub 6 liability, this court found that it was actually necessary to remand the matter for purposes of reapportioning liability. I'm not even asking for that here. I'm saying to your honors that you have a record in front of you which shows absolutely no evidence of negligence on the part of One Bryant Park, and your honors can just simply set that portion of the verdict aside in this case.
Thank you.
Thank you.
Your honors, can you hear me?
Yes.
Okay, because my camera mysteriously disappeared after 2 hours it was on, and
I saw you
can hear you. We can hear you. So go ahead.
As long as you can hear me,
yes.
You know what I look like anyway. So.
Yes.
May it please the court, Scott Singer for the plaintiff respondent. I just want to point out that with respect to this issue of the apportionment of liability, the testimony was undisputed. And by the way, the defendants concede that this plywood structure at the threshold obstructed plaintiff's view of the drain opening. That's undisputed. They concede that. I don't know what it is that the counsel expected our client to do. He had a tough hurdle to just clear this 18-inch high, 1 inch, it was about a 1 foot wide plywood threshold, and to get over it, he had no reason to. He was looking ahead, trying to get where he was going. And in addition, the drain opening was cluttered with debris. He would have no reason to see that. And the jury was entirely appropriately attributed 5% comparative negligence to the plaintiff. This satisfied the standard. And as this court has held, if there's a fair interpretation of the evidence that would lead to that allocation of fault, then the allocation should be affirmed. So we believe that the court appropriately found 90%. The jury appropriately found 90% attributable to the main defendants, and 5% and 5% to the plaintiff and the other co-defendant. As to the award of damages, it was consonant with the cases. I've cited the cases in my brief as to both pain and suffering. And lost earnings and the medical expenses. All of that was proven. All of that was established. You should note that the defendants didn't present any expert proof. So the estimates as to the damages.
Mr. Singer, the defendants didn't put on any experts on any of the damage issues?
Well, they put in a radiologist on the medical issues, but he didn't really opine about it.
I think the jury didn't buy. Was that Dr. Fisher?
That's true, and they said that they didn't find it credible. I mean,
they
after
wanted
all,
to strike his testimony or something.
Yes, they put in they put in a note to the court that they wanted to know if they could strike his testimony because it was not credible. All he did was look at the X-rays. He didn't look at the actual human being. And
other than Dr. Fisher, they did not put on
No,
any medical or experts to any of the damage points.
Economics, and these were the damages were entirely realistic and based on the evidence that was heard. I just want to briefly remark on this thing about his work record. Remember, he didn't work after 1991. He went back to work as a construction worker. He went to IT work after 1991, and he didn't return to 2000 till 2008. So it was entirely appropriate for the jury to base his earnings potential on the last 11 months that he worked because of that very large gap between his initial work as an iron worker and his recent work pre-accident. I've also cited cases that I think are appropriate on the issue of pain and suffering. If there are any questions, I would be happy to answer them. Really, the only remaining issue is damages, and I think that's was appropriate. So, does the court have any questions?
Thank you, Mr. Singa. Thank you, Judge Friedman.
Your Honors, Darrell John, I have the responding component in the case. The appellants in this case are making a claim based on a provision of contract that's called temporary protection. We have to remember that this construction started in 2006. And at that point, component and the general contractor was doing work called core and shell. In other words, the concrete deck had openings in it, the walls had openings in it, and they required plywood to cover before the permanent installations came in. Fast forward to 2009. Component no longer has 60 employees on site as part of its 12-month program for the temporary protection of these openings. Instead, it has 2. The 2 employees are working on the 51st floor doing drywall work. There's 2 million square foot of space in this property. According to the appellants, a drain was installed at some point in one of those openings. According to Mr. Pearson, who is the foreman for component, once there's a permanent installation, that is the end of temporary protection. So in other words, there was temporary protection at one point on the hole in the floor. The plumber comes in, installs a piece of plumbing, and it has a cover. It comes with a cover. In appealing...
Your point is that at the time this happened, you no longer had responsibility for this condition.
That's exactly the point, and the jury had ample evidence of that. The reason why that's even brought out strongly is that the appellants made a demand for any extra work, contractual work, that was performed in 2009. And on page 1323 and 1325, there's extra work for covering openings. And that just cuts against their argument that this temporary work for covering openings on the floor continue on. But part of the problem is the characterization of a drain pipe as an opening. I'll tell you why. When the drain pipe is installed, according to Mr. Pearson, that contractor becomes responsible for that. The plaintiff the appellant in filing this appeal said that they don't know and there's no evidence why this didn't have a cover. But on page 329 of the record, 479 of the record, and 1004 of the record, the plaintiff, Mr. Morrison of Tishman, and Mr. Pearson all testified that this pipe came with a cover. On 479, Mr. Morrison said, well, we didn't put the cover on because we didn't want it damaged. So now, somehow, by ESP, these 2 guys on the 51st floor are supposed to know that they decided not to put the cover on the pipe that it came with and are supposed to shoot down plywood on top of this drain. The problem with that is that in all of the testimony, they're talking about a hole and trying to distinguish a hole from a drain pipe. But the contract doesn't talk about holes. It talks about openings in the floor. And it talks about how those openings are covered. And it's covered with shooting down plywood. But at this stage, I'll read you the testimony. Mr. Morrison said it doesn't get a cover until we walk out of that room. It was their decision not to cover that. But at that point, when they decided not to put the cover on the pipe that it came with, they have to notify component. That's where the extra contract work order comes in. And there's 2 of them, but not for this pipe. And that's why the jury said this is all Tishman's fault. They knew of the pipe being there. They knew they weren't going to put the cover on it, but there's no work order telling a component to come there and cover this thing. So the jury correctly apportioned testimony, the liability. As far as, the appellant also makes an argument that even if that was the case, even if this was extra contractual work, that the contract contemplates extra contractual work. The problem with that argument is that it specifically requires Tishman to initiate a work order from which payment can be made and a requisition. And those work orders are produced between pages 1318 and 1329 of the record, but none of them for a pipe on the 7th floor in the mechanical room. They're for different locations, for different openings. So we know in 2009, when this took place, that such covering of holes required extra work orders that were outside the contract. But they don't exist in this case for this hole. There is no other party that the jury had but Tishman to blame for this, because they were aware and didn't put component on notice that they wanted that hole covered, not with its drain hole cover, but with a temporary cover that was made of plywood. As far as the argument that there's a conflict between the jury's finding of 5% and its finding that the contractual work didn't arise out of the Tishman work, the judge said that under PGI 210, the jury could have found negligence outside of the contract and allowed on closing arguments for the appellant's attorney to argue that the threshold could have covered the hole. But the problem with that, as the judge noted on a motion to re-argue, is that there was no evidence, absolutely none, that that drain hole existed at the time that that threshold was created. So there would be no way for component to know when the threshold was created that they had to warn of a drain hole, because there's no evidence that the drain hole existed before that threshold. So the argument that the jury could have found, 5% based on the contract for the threshold doesn't fly, according to the judge. The judge said that that argument was raised on closing by the appellants and improper, but she said there was some wood that was found within the drain, and component is the carpenter, so maybe the jury found 5% for them outside of the contract. Well, we made a motion to re-argue, but the judge denied the re-argument based on PJI 210, and we granted there is a conflict. But the jury specifically had 9 days of testimony about who was responsible for this and found Tishman responsible. And we argued that the 5% doesn't make any sense. It has to be based on that threshold that was thrown in at the closing arguments. And the judge said, thank you.
Thank you. Mr. DiStefano, you have a minute.
Thank you, Judge. So with regard to that, this court very clearly held in its earlier decision on summary judgment that component's duty rose from its contract. So everything that was just said about covering holes and erecting plywood thresholds, the jury determined that component was 5% at fault. That fault has to be attributable to the contract. Component did not appeal. It is now bound by that determination. The only question is whether it should be limited to 5% or whether or not it should be increased to something more in line with component's responsibilities, which included maintaining protection throughout the course of the construction, and this construction was clearly ongoing. In fact, that floor had not even been completed because it did not have the waterproof covering yet. So for a component to say that it had no obligation is not only in direct contradiction to the evidence, but is also in contradiction to the daily logs, which said the component was maintaining protection throughout the site on the day of this accident. So for that reason, it needs to have its 5% increase. With regard to the plaintiff, again, if this threshold was so high that it needed a feat of acrobatics for him to be able to cross it, then he needed to exercise some modicum of care. He says he exercised none. He was not looking where he was going. He was looking at his coworker, who, by the way, his coworker was able to go in and out of that room multiple times because he had loaded material from outside the room onto a cart inside the room. And as far as we know, the worker didn't have any problems. But the plaintiff needed to take that half second. That's all he needed to do. And for that reason, his 5% should be increased as well.
Thank you. Thank you all.
Thank you, Ron.
Sumpus versus 1109 Lexington.
Mikhail Schenker for respondent.
Is the appellant present?
Appellant is present. I apologize. I had to use a colleague's tablet.
Okay, you're here, so go ahead.
Thank you. Good afternoon. It's an appeal of two orders issued by the Supreme Court in an access proceeding commenced under RPAPL 881.
So why isn't what Supreme Court did a reasonable approach to this license under Section 881?
Well, a license without an open-ended license without a fixed date is a perpetual inconvenience, which balancing the interests doesn't outweigh any possible hardship to granting a fixed date. The vast majority of the case law that I've found, and I searched high and low to find a case that fixed a month-to-month license, but the vast majority of them do impose a durational limitation and even have an escalating license fee if it goes beyond that term. I don't think I think it's unreasonable and unnecessary to have a license that.
But if this license seemed to be abused, if it went on endlessly, there'd be nothing to stop you from coming back to Supreme Court and saying, look, Judge, you have to bring this license to an end. There's no reason for it to continue on.
Well, the judge certainly didn't have.
I mean,
that.
This is not forever. No one thinks this is forever.
I think it's important, though, as far as the party's expectations and as far as setting our tenants. Now.
We all know that construction in New York City is anything but predictable, and things don't always happen as they should, and certainly time-wise. And so I can understand why it's difficult to make a fixed date, but certainly even without Judge Rackauer saying, and you can come back and see me if this goes on too long, you can go back and see the judge if it goes too long, because judges have their cases and they're ongoing. And in this particular case, there was somebody on the other side, and they had worked out a license with them. So why isn't it reasonable to have had this situation? I mean, what else was the judge supposed to do here? I mean, what else could the court have done?
Well, I think ordinarily in this situation, and the situation that you described where we go back in court, I think shifts the onus onto the party that hasn't been compelled to give access, where we have to go to court and debate whether, what's the progress of the status of the work, whereas the majority of the decisions that have been written that impose a durational limitation give the petitioner the ability to return to court if he needs an extension of time. The work that's left to be done is particularly within the petitioner's knowledge. It would be much more difficult for us to come in and speculate as to the status and why things are delayed, or have particular knowledge to establish that.
But counsel, this is Justice Weber. It seems to me that it was to your advantage to do a month to month, because each month, therefore, you're looking at the progress. You can see the progress, and there's a value of $27.50 per month for the fee. So I would think that it's to your advantage. Each month you're seeing what's occurring, what's not occurring, and then it gives you it's an update, as opposed to setting a 9-month expiration date and then again the onus would be on you during that 9 months to make periodic inspections. Now, you know each month what's going on.
Yeah, but there's no certainty as when this will end. And we have commercial tenants and residential tenants there who are directly impacted and affected.
I thought that they had also made overtures to the residential and to the tenants in terms of how their daily lives would be impacted by this.
And to my knowledge, no.
Thank you.
Thank you.
Mr. Schenker?
Hi, Your Honor. Basically, I've heard all the comments voiced by the justices that I was going to voice myself, but you did probably a better job than I would. I would like to point out that what appellant is basically saying, that as a matter of law under 881, the court can never issue a month-to-month license until completion of the project. That is simply not the case. There is no language in the 881 statute that provides that limitation, and there is no case that says that. The fact that numerous cases provided a particular time frame, well, each case is uniquely different from another. Most cases did not involve a bench trial, whereas here, Judge Rekar was able to fully view the testimony of the principals and the expert engineer and question everyone about the scope of the license and the work and so on and so forth. I mean, I think that at any point, if they feel that this is going too long, and I will just point out that because of the coronavirus, we were delayed by 7 months, 3 or 4 months when we could not do any work. And currently, we restarted in late July, early August, but there is a limit that the DOB places on us how many workers
you didn't pay for the license during those months, did you?
We paid.
So you had nothing going on and you paid?
Correct.
And counsel, there were some issues with respect to stop work orders. Were those all resolved?
Those were fully resolved. We have not had a single stop work order since April of 2019. When this proceeding was still ongoing. There is not a single complaint that Mr. Hamill's client made to the DOB. The protection that we have in place is very passive. We cover the rooftop, which does not affect anyone, and we cover the trash cans in the backyard that really doesn't affect anyone. What's the peeve, the real peeve here for the owner of the licensee, the appellant, is that we
sidewalk shed.
Yeah, sure.
I mean that's what's driving all of these issues.
But it's your contention that you're permitted to have that.
Correct, as of right, and it was not part of 881 application, and it's not part of 881 license. So even if you stop the license right now, nothing's going to stop the shed from from staying, and we cannot take it off until the Department of Building sees that we've completed all the work and permits us. Because at the end of the day, this sidewalk shed is a great inconvenience. I recognize it, but it's better to save lives than save a dollar.
Okay, thank you both.
Okay. Yes. Can I just have 1 minute?
Go ahead.
Respond. I apologize. I'll keep it very brief. I'm not saying that a month-to-month license it can't be granted as a matter of law. I'm saying, in fact, in this case, it was not even requested, nor did the judge ask the parties to brief the full scope of that issue. The fact that the judge granted a month-to-month license after having a license fee hearing, which didn't address whether it was reasonable or necessary to have an ongoing license on that type of basis.
Well, what did you think the hearing was about? What else were you talking about if it wasn't about a fee for a license?
It's my knowledge, and I discussed it with the attorney who handled the hearing, but even reading the transcript, it was limited to exclusively the issue of fees. What's the reasonable amount?
But a fee for a license, so what did you expect the license to be for? I mean, what did you think the time was supposed to be? I don't get it.
Well, I would have expected the scope of the license. I mean, the parties
But wouldn't the
themselves
fee
had-
also depend upon the length of the license? I don't understand how you can have one without the other. I mean, there's going to be one fee, I would think, if it's going to be for a shorter term, and another fee perhaps if it's going to be for a longer term. So I don't see how you can have a hearing as to fees without some testimony or argument as to the duration of the project. I just see it goes hand in hand.
And I agree with that. I think the parties, and even the respondent here, both parties' expectations was the duration of the license would be around 9 months. I think the access was that they requested in the petition. That was what we anticipated going into the hearing. That's what they were asking for.
Nobody expected COVID-19 to hit. So
no, and to that point, I totally understand. And it's not that I wouldn't. It's not that we don't want to work with them, but to that point, COVID-19 also affects vacancy rates and tenants already.
I think that's what Judge Rackower was hoping, that there'd be some cooperation between the two sides, and obviously, I mean, I know, I'm sure you would prefer to have it come to an end at a set time, but there's nothing which stops you if it goes on for too long, and the work seems to be finished or anything like that. There's nothing which stops you from going back to bring it to an end. So it's. Absent cooperation, it's I recognize it's a difficult situation, but
yeah, I really believe that putting an open-ended license with no term is just not. It's counterintuitive with the statute, which shouldn't burden the party compelled to give access.
We'll take a look at it. Thank you
Thank you so much, and I apologize for the issues, troubleshooting.
We recognize the technological issues that we're all working with. Thank you.
I'm terrible at it. Thank you.
Thank you, Mr. Schenker, for being patient.
No problem.
So I'm going to call our last case of the calendar now as Total Assets versus Metlife. As I indicated earlier, Justice Kern has recused herself. So as soon as Justice Kern leaves the session, the appellant can begin.
Okay. Thank you, Your Honor. Jim Ferraro on behalf of the appellant. This case, the crux of this case is the interplay between the abandoned property law of New York and insurance contracts as they play out with the abandoned property law. And this is not a new issue in New York. It first came up in the Moore decision, which the Moore cases that went through the New York appellate system in the 1940s on a deck action, and the Supreme Court of the United States in 1947. But the real issue, and here's the crux of it. Our position is that when an insured dies on a life policy, a payment is due, either to a beneficiary, if one is located within 3 years, and if not, to the state of New York. There is no third option. The way that insurers have been operating in New York, or a lot of them have been, to a great extent for several decades, is that there's a third option. Under the insurance contract, and it's legitimate under an insurance contract between an insurer and a beneficiary, that a claim is not payable to a beneficiary unless there is a proof of claim and a notice of death. Without that, they never have to pay a beneficiary. Okay. Our position is that the abandoned property law under 700 is very clear that after 3 years, money is due to the state if the beneficiary is not located.
And now, how does the insurance company know to look for the beneficiary? I mean, you say it's abandoned after 3 years, but how do they know, like, when does the 3 years start going? If there's no beneficiary, how do they know to start looking?
Right. Well, it's basically as follows. The clock starts ticking on the death of the insured. Okay.
And how does the insurance company find out? Who tells them if there's no beneficiary?
Right. There's multiple ways for them to find out, and this has been discussed in other cases. Okay. The first is, one is you can look at the master death file. That came into existence in 1980. It's been around since 1980, and actually, because of the abuse that's occurred, not just in New York, but in other states, it's been codified now that they have to look at the master death file as of 2013.
And
But
that comes out, how often does a master death file come out?
you can go on it any day of the week. You can just go online and you just run
Oh, it's
social
on,
security.
okay, got it,
Yeah.
thank you.
But in addition to that, Your Honor, though, there's other ways, okay? And this came out in the Purdue decision, which is the West Virginia Supreme Court following New York in 2015, which is the exact same facts we have in this particular case, which interprets more, which is the New York decisions and the Supreme Court of the United States decision. They discuss other ways. Number one, as an insurer, okay, you have certain obligations and duties to the state of New York under the insurance law. And one is to monitor your policies. And one is that after 3 years, and that's why there's a grace period. Originally, it was 7 years. It's now 3 years. There's a grace period from the finder beneficiary because someone should come out in 3 years. And if they don't, okay, whatever. How do you find out someone died? You call, you send letters, you contact agents, who there's always an agent on a policy. And most importantly, and this is the most egregious fact that was also referenced in the Purdue decision, it's in our complaint. There are umpteen instances where the insurance companies were monitoring the master death file like a Swiss watch every year to determine whether the policyholders were alive on annuities. Because for annuities, you don't pay if they die.
Okay.
You only pay when they're alive, okay? So now what happens here, now with the death policy, there's umpteen cases where there's both a life policy and an annuity policy on the same person. And guess what? They checked it like a clock on the annuity. They know how to do it. Now, it wasn't a requirement, but it was part of their general, that was one of the things they could have done since 1980 under their general duties and obligations to the state of New York to eschew if they can't find a beneficiary. And it's really crazy. It's been there since then. You find these situations where the annuity, gets cut off. They get cut off, and they don't pay a life benefit. So
you're making claims going back to 1980, aren't you?
Our claims go. The claims go back.
Isn't there a 10-year statute of limitations on this?
Yeah, it's a very good question, Your Honor. There's two statutes that come into play. Under the APL, there is no statute. Statute of limitations is not a bar on achievements under the APL.
But isn't that only for the controller? That's
correct. But we are a key TAM. We're a key TAM plaintiff, and our action is on behalf of the state. We are here on behalf.
Isn't your action coming under the finance law? And the finance law does have a statute of limitations, does it not?
It does, Your Honor. And it's a 10-year statute of limitations. And the violation, and here's the violation that pops up every year. There's an obligation to file a report. It's called a holder report. Every single year by May, they have to file a report showing all of the outstanding unpaid claims that are out there. Then they publish over the next couple of months to try to find these unknown beneficiaries or unclaimed funds. And by September, if it's not located, they have to sheet, if it's 3 years later, to the state of New York, who acts as a conservator for the funds. But the problem is, every single year, if they've got the same claims plus some each year on that report, that is a false claim every time they file that report under oath, alleging here's all the achievements we have. Now, they could have put it on. If they find one, a given year, they could put it on the report. But if they keep leaving it off every year, Your Honor, it's a violation renewed every single year. Every single year. And
so I'm sorry, counsel, you're arguing a tolling in the statute of limitations based on a continuing violation. Is that it?
No, it's not a tolling. It's a renewed violation. It's a new violation every year, Your Honor. And whatever is not on that holder report is a violation. So even every year, it's a new violation. Not really a tolling, Your Honor. It's similar to tolling, but it's not a tolling.
Why isn't the violation happen at the time of death?
The violation? Well,
yeah, I mean, so you're saying their report is false, but they were obligated to turn over the money at a certain point in time. And why should the New York False Claims Act 10-year look back be pushed aside because you say, well, they keep on making this false claim? I mean, the false claim is what they're reporting, right?
It's a very good question. However, every year that they file a report, they keep leaving the same death benefit off. I mean, that's a new violation. I mean, they could put it on any year that they like. I understand.
The entitlement to money comes from the death benefit, doesn't it? Not from the false. Your claim comes from the fact that it's a false report, but their obligation comes from the death benefit.
Right. Their
obligation to the state comes from the fact that the death benefit was due. It wasn't paid. It should escheat to the state.
Right, and that's where
you're looking to step in. You're not looking. It's not on the falseness of the report.
Well, it actually is both, because you've got two things going on. The report that gets filed every single year is under oath and it attests to what's out there. The APL. Okay, if this was not a false claim, just an APL, there's no statute on APL. The insurance company cannot use that as a defense that, hey, we don't have to sheet any money to the state because, there is no statute, because the reason is no one's in a better position to know about the policies than the insurance company. The state has no way to know how many policies are out there and whose policies are out there.
Any other questions for counsel? Let's start hearing from the respondents then.
Thank you very much, Your Honor. I'd like to address a few of the points that Mr. Ferraro made. First, he's asking this court to interpret the New York abandoned property law in a way that the New York Comptroller's Office hasn't interpreted it or enforced it, and then to find that the defendant's failure to adopt that interpretation amounts to fraud under the False Claims Act. There's no False Claims Act violation here for several reasons. First and foremost of which is that at the time it issued, defendants had no legal obligation to escheat this property, and the case should be dismissed on that basis alone.
But Counselor, is that correct? Doesn't the case law more, for example, stand for the proposition that you do have to escheat whether or not you're on notice of proof of death?
So the Moore case, Your Honor, is a constitutional analysis of whether it would be violative of the Contracts Clause of the Constitution to require escheatment in the absence of proof of death. But that case, to say that case created a strict liability regimen for insurance companies where they have to go out and conduct an investigation outside their records, that goes way beyond anything in the case.
Well, are you suggesting it's an onerous investigation to look at this very cheerful death master list or whatever it is?
Well, what I'm suggesting, Your Honor, is that there was very clearly no obligation on an insurance company to search the death master file in the relevant period. And we know this because the New York changed its law and changed its regulations 2 years after this suit was filed in order to require that for the first time. And the statements, we cite this in our papers, the statements made by the Office of the Governor and by the New York Insurance Department in connection with this made very clear that this was creating a new requirement. And even though in undertaking to look at the issue, they understood that some insurance companies were using the death master file to avoid making annuity payments they did not owe. And frankly, that's what it was created for. That's what it's for. And that they were not also using it on the other side of the house to look at life insurance policies. And the reaction to that was
so essentially the argument is the left hand doesn't know what the right hand is doing, and that's okay.
Well, there's a very legitimate business reason for that, Your Honor. If you're a family of an annuitant who's died, you may not have much incentive to call the insurance company and say, please stop sending these checks.
I'm not saying, I mean, I don't know personally, I'm not saying there's anything wrong that you should check this to not have to pay the annuitant, an annuity to somebody who has passed away. I mean, that I understand why you might want to do that. What I don't understand is I look at more as going farther than you do and as requiring you to escheat this these unclaimed life insurance proceeds, even in the absence of absolute notice and proof of death. You're looking at these death benefits to help you out with the annuities. Why are you not looking at them to see if you have unclaimed property and doing what the Supreme Court said you should be doing with it? I don't get that.
Well, I have a couple of responses to that, Your Honor, if I may. One is that that case did not tell insurance companies what to do or create a strict liability regimen. This law is interpreted and enforced by the Comptroller's Office. The Comptroller's Office has never adopted this interpretation.
But wait, what the State Comptroller's Office is what you're saying?
That's right. And it's a creature of the State Comptroller's Office. And so if you look at the support for the defendant's interpretation of their obligations under the abandoned property law, I believe it's overwhelming. There's the plain text of the law, which requires that insurers to escheat monies that are due and payable under policies to beneficiaries. That ticks and ties to the New York insurance law, which has a proof of claim requirement. The New York Comptroller was quoted in a law review article in 1976 for the proposition that unclaimed property obligations don't attach until there's proof of a claim filed. And there's a follow-up on that as well. There's no New York authority on this. There's none. There's no New York authority on this theory that Mr. Ferraro has pursued, and at all. To have any authority at all, they go to a West Virginia case interpreting a different unclaimed property statute that was decided 5 years after this claim was even filed. And it interprets a statute that uses language that imposes a strict liability situation on insurers. The New York abandoned property law doesn't do that. In addition, New York regulators, like I said, they all took the position that the requirement on insurers to search the death master file was new. And when they looked at this starting in 2011, they understood that the death master file was being used to avoid annuity fraud, and that was fine. And they thought, geez, maybe it would be better if it were also used on the other side. So they wrote a new regulation. It's much easier just to do an enforcement action, right? New regulation, new statute to require it. And that just makes it very clear not only that there was no requirement before, but that insurers were very reasonable in thinking there was no requirement. They're routinely audited by the controller's office, who's in their offices and communicating with them about what the obligations are under the unclaimed property law. And when New York revised the law to require insurers to search the death master file, it still expressly allowed insurers to require satisfactory proof of loss, such as a death certificate, to verify a death. That was the 20. And so meanwhile, you also, I'm sorry.
If you want to finish up, go ahead.
But the last point I was just going to make on that is that the very fact that companies industry-wide followed the same interpretation really supports the industry's good faith, and we believe supports the notion that regardless of what Connecticut Mutual is interpreted to mean or not mean, insurers had a reasonable basis as a matter of law to understand that it did not require them to have a strict liability situation where they're investigating outside of their books and records, because there's no law, no authority, no statement from the controller, no audit, no adverse audit finding that would have told them that.
Thank you.
Thank you.
Okay. Your Honor?
Yes.
You're on a rebuttal. Okay, brief.
Now, I thought that there are two more respondents appearing on this.
You're absolutely right, Your Honor. So I'm sorry. I'm sorry.
I don't see them on the screen at the moment.
I see them. I see them. They're there. Your Honor, we were giving our time to Ms. O'Connor to address these issues, and then we were going to follow up on some of the others. So I'm sorry, Your Honor.
So
yeah, we apologize.
Ms. O'Connor is doing the whole argument?
Yeah, and I'm happy to address some of the issues, but we let her go first. And
yeah.
I thought there were going to be 3 attorneys arguing for the respondents. Is that not so?
Your Honor, we're available if you have any questions about our specific briefs, but because the arguments are tied together, we think Ms. O'Connor it's best if she handles.
Ms. O'Connor, if there's something else you want to say, go ahead.
Okay, thank you very much. So just
I only stopped you because I thought your co-counsels were taking over, but
I was thinking that was a very fast 12 minutes. I touched briefly.
Remember, I said it's split 3 ways, but obviously it wasn't going to be. So we're right. Go ahead.
So, thank you very much. So I want another couple of words on the scienter argument. We don't believe there's anything here to suggest scienter. And we also believe that scienter is negated by the fact that insurers, for all the reasons I just articulated, had a very reasonable good faith belief. And I believe that the fact that the law was changed to require insurers to use the death master file rather than any type of enforcement proceeding by the controller or otherwise, essentially establishes as a matter of law that our belief in what the law required of us was reasonable. It's absolutely clear that reasonable belief as a matter of law can be decided on a motion, and we cite cases to that effect. And Mr. Ferraro does not cite anything to the contrary. He cites a case in which facts had been alleged to suggest that, in fact, the company wasn't acting on a reasonable belief, and in that case, on those facts, on those circumstances, you couldn't reach the question. A couple of other points to just briefly make while I can. There's a lot of allegations in the complaint suggesting that insurance companies had actual knowledge of death of policyholders, and that this is a basis for scienter. We disagree with that very strongly. And for starters, this is not a suit by the controller for escheatment. This is a fraud claim under the False Claims Act. So what's relevant are allegations of knowledge that a reverse false claim has been submitted, not potential knowledge of a death. And second, this idea of knowledge of death being the trigger for requiring escheatment is simply not a standard that exists in New York law. And if you look at other states, some states have that actual statement in their abandoned property statute, that if you have knowledge of a death, that triggers escheatment. That language does not exist in the New York unclaimed property law, which is unique. Third, the supposed knowledge allegations that exist are very conclusory, general, clerical errors in naming, the like, which are very, very far afield from anything that would need to be alleged to get all the way down the road to this reflects recklessness as to an unclaimed property report. If you have issues in the names or dates in a database of millions and millions and millions of policyholders, that is not evidence of recklessness. At most, that would be evidence of clerical error, which is not enough to support a claim, which doesn't even establish that no benefit would be paid to a known individual, much less that would all turn into.
But I mean, if you're issuing policies, how can you have policies with no names, no dates? I mean, that just does not make any sense. And you have a whole bunch of them. That sounds like more than a clerical error. I mean, that's a serious error.
Respectfully, I don't agree with that, because if you think of the lifetime of a life insurance policy, you may have policies that were issued on paper records in the 1930s, 40s.
Yeah, but you still have a name and a date and things like that. And your name.
There are instances, obviously companies strive to have the best records they can, but the New York insurance law specifically recognizes that in many instances companies don't have every bit of data. And when they passed a new law on requiring death master file searching, there was
every bit of data is one thing. A name is, I think that's not every bit of data. I could see if perhaps you don't have a social security number, or maybe
the updated address.
But I think a name is something that would be essential to the policy. That I do not understand.
Well, I think it's really an insurance law question. It's not an unclaimed property law, escheatment, False Claims Act question. In many instances, you can have somebody with a maiden name who then gets married. You can have, things that can happen, right? People can change their name, they can change their address. Things are much more electronic today than they would have been 50, 60, 70 years ago. And a name alone, in any event, wouldn't be enough to find someone. So when you look at this new law that exists, it specifically acknowledges that companies may not have all of the pieces of data and provides instruction on what to do if they don't have all the pieces of data to still try to run a death master file search. But I think the fact that the insurance law acknowledges this as a reality in the industry, that is not something that is reckless or should be punished, but rather is just a reflection of issues that can develop when there are just millions and millions upon millions of policyholders over the course of many, 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 many decades. I think it makes clear that none of those issues would support a scienter finding here. Nothing like the False Claims Act is not intended for anything resembling negligence, anything resembling a mistake like that. It's for fraud. And in the absence of an obligation to do what Mr. Ferraro suggests we should have been doing, we just don't see any basis for fraud here.
If we have one more moment, I would like to address the arguments on the statute of limitations. And in particular, I think the court's question was exactly right, that the New York False Claims Act has its own statute of limitations, which is a 10-year statute of limitations. And the provision that Mr. Ferraro referred to in the APL, the section 1400, that says there shouldn't be a limitation that affects the right of the controller to bring an action to compel escheatment, or the right of the controller to bring an action to enforce penalties and interest under the unclaimed property law, wouldn't apply here when we're looking at the New York False Claims Act. In addition to this continuing violation argument, where Mr. Ferraro has contended that that the insurers had an obligation each year to cumulatively report all prior year property is inconsistent with the language of the statute, as well as Justice Masley pointed out in Section 703 of the abandoned property law. It says that annually you file a report in September for all property that was deemed abandoned as of January. So it contemplates an annual report that files all property that became deemed abandoned in the prior year. In addition, the way that the statute is set up, you have an interest and penalty provision that runs from the date that property should have been deemed abandoned. So under the unclaimed property law,
when should it have been deemed abandoned? When does that,
what's 3 years after the dormancy trigger.
So when does the 10 years start to run, in your opinion?
When we should have reported it in that year. So you file an annual report every year. And so if the dormancy period ran 3 years, then all the property that should have been deemed abandoned in that year, for instance, in 2000, if I had something that the dormancy period started in 1997, then in 2000 I should have reported it. And assuming you had scienter and everything else, then in 2000, that was my reverse false claim.
That's when, okay.
Yeah.
Okay, thank you.
But I don't have then a reverse false claim in 2001, still as to that piece of property that should have been reported in 2000. Instead, what the abandoned property law says is you have an interest provision that runs for 10% a year, which is a lot of interest. And you even have daily penalties that run for every single day that my report is late. I have a $100 daily penalty that accrues. So it would be anomalous if I should have reported something in 2000. I've got the interest penalty and the daily penalty accruing. And then according to their theory, I should have reported it again in 2001. And I now have False Claims Act liability because I didn't cumulatively report it every year, when in fact the statute contemplates your interest and penalties run from that first year you violate the statute. So that's all.
Thank you. Mr. Ferraro?
Yes, Your Honor. Rebuttal. Okay. First of all, the timeline of what transpired here. TARS got involved with the Attorney General in November of 2010, Your Honor. They worked with them. There's hundreds of emails, dozens of meetings, over 2,000 hours of time over the first 4-year period. I want to explain what happened during that period of time. On June 11th, subpoenas went out from the Attorney General with the assistance of TARS. They worked with them exclusively, processing information, guiding the Attorney General, and that's why they filed a statement of interest in this case. On July 11th, the comptroller, 2 weeks after the subpoenas went out, issued 308 letters demanding information on sheetments. And guess what happened? Listen to this. 2012, Prudential, okay, who from 2009 to 2011 issued 100 policies per year to the state of New York, all of a sudden in 2012 must have had an epiphany. They issued 7,000 policies in 12. Okay, that's before the master death rule. 2013, they issued 9,000, 90x. 2014, 5,050x. Guess who had an epiphany the next year? Metlife didn't have an epiphany in 12, but theirs came in 2013. They were a 500 a year player, just enough to keep the comptroller off their backs.
Counselor, can you address the defendant's fraud arguments, please, and specifically with respect to scienter?
Yeah. Okay. With scienter. Okay. The knowledge requirement on the FCA 188, knowledge is defined as actual knowledge, deliberate ignorance of the truth or falsity of information, reckless disregard of the truth or falsity of information. And that's what we submit happened here when we have policies that are under the name John Doe, Jane Doe, hundreds of policies, incomplete social security numbers, improper amount of digits, unassigned by the SSA, premium deficiencies. How about this one? Where a policy, they're paying monthly premiums, and all of a sudden the premiums stop, and instead of trying to find out if someone died, they exhaust the cash value. They keep taking premiums over the next several years. So there's literally thousands of these in their records.
I'm sorry. You also, with respect to the particularity requirement, you assert that all the defendants engaged in all this alleged conduct. But you don't separate each insurance company. Isn't that an obligation here that you got to separate under our case law, that you have to separately identify the conduct of each of the defendants?
If they have diverse acts, if the acts are different, okay, if the acts are different, under the Christie decision from this court.
Well, isn't this a conclusory statement? All defendants engage in all alleged conduct.
Well, they did. The conduct, all the specifics I just talked about, every single one of them did it. And it's detailed in pages 23, 24, 25 of our complaint. The Social Security issues, the birth date issues, the name issues, the premium deficiencies, they all did it. And under the FCA, we do not, for pleading, okay, specifically under 192, we do not have to name specific claims or anything of that nature. In fact, the exact language of that is under 192, we do not have to identify specific claims, specific records, or statements used. If the facts alleged, if true, provide reasonable indication that one or more violations of 189 likely occurred, that's enough. And every company did this. Now, we could go back and just restate the same exact paragraphs 13 times, and and the answers would be exactly the same. Because we don't have the exact number of how many times we did it, because we don't know if it's 5,262, and we don't have to know that according to the FCA 192. We simply don't. With reference to the comptroller, our key TAM complaint is filed on behalf of the state. And if you look at the definition of the key TAM, it includes these state officials like the comptroller. The attorney general worked for 7 years with us, with TARS, and they filed the statement of interest in this case. There's no administrative proceeding bar, and they also said there's no public disclosure bar. They've agreed to it. They've worked with us for 7 years. They want to pursue this. That's why they filed the statement of interest. It's a legitimate claim, and what's happened here is just, it's really egregious that, Metlife all of a sudden issued 30,000 claims in 2013. They did 500 the year before. How did that happen? All of a sudden, they got 30,000 proofs of claims. You have to believe the defendant's argument that 30,000 proofs of claim came in from beneficiaries who, in turn, then abandoned their claims. Because that's really what they're saying when you really think about this.
Mr. Ferraro, finish up.
Yes. Well, I'd really ask the court to carefully review the Moore and the Purdue decisions. They are right on point. If there's any two decisions that relate to this, it's those two. There are dozens of cases here that are only about insurance contracts with nothing to do with achievements. But those two are right on point, Your Honor. Thank you very much for your time.
Thank you. Thank you, all.
Thank you.
This concludes oral arguments for today. Court is adjourned.
Good night.
Thank you.